Good morning, everyone. It is 8:30. We're going to go ahead and get started on time. I want to do the normal introductions. My name is Elizabeth Well, and I'm the legal director here at Ohio Crime Victim Justice Center. See, we already have 116 people who have joined us, which is very exciting, and we're looking forward to speaking with you today. I'm joined today by three members of OCVJC's staff. So we have Sierra Davis, who is an advocate, Morgan Keelholtz, who is our attorney in the Cincinnati region specifically, and Leah Williams, who is also an advocate. And Morgan and I are going to be doing the presentation, and Leah and Sierra will be assisting us with questions and any needs that you all have. And we'll talk about how to communicate questions and things like that in just a moment. We're also joined by Ashley and Stephanie, and very excited to have them to provide interpretation services. I have already promised them that I will attempt to speak slowly. For those of you who have seen me present before, you know that that struggle is very real for me. So we're going to talk today about victims' rights in Ohio post Marsy's law. And we're going to speak not only about the constitutional amendment that is Marsy's law, but also about legislation that has now been introduced in the Ohio House, the law as it currently exists in the revised code, and a lot of other sources of victims' rights law. So let's get the housekeeping stuff out of the way, and then we will go ahead and get started with the content. So when you want to ask a question for a presenter, and we encourage you to do that, please use the Q&A option as opposed to the chat option. We're going to have myself, Morgan, Sierra, and Leah. We're all going to be monitoring the Q&A, and we will either answer your questions live or we will send you an answer in writing. We will be less able to completely monitor the chat as well, just because there tends to be a little bit more activity in the chat. We will ask you to use the chat for specific purposes at specific times. And we will be trying to keep an eye on that, but the best way to ensure that we get your question is to ask the question using Q&A. If you want to chat something to us, such as I'm having a technical difficulty, you can send a chat to all panelists. If you want to say hi to everyone who's joined us this morning, and we're up to 143, I'm so excited. You can send that chat to all panelists and attendees. For the attorneys who are joining us today, the chat is going to be important because at various times throughout the presentation, we're going to ask you to send us your name and your registration number to all panelists using the chat so that we can confirm your attendance and your participation as we are required to do by the Ohio Supreme Court. So we will prompt you when we need that. And again, we'll do that at various times throughout the presentation to make sure that you are still with us and make sure that we're checking all the boxes for the Supreme Court. All right. If you are an attorney and you're seeking CLE, which I would assume you are if you're on this presentation, we will submit the CLE credit for you with the Supreme Court. We will not need you to do anything except for verify your name and registration number at the different times that we ask for that throughout the presentation. When we get that from you, we'll be able to submit the information to the Supreme Court, and you will not have to do anything. For CEUs, as you know, you'll need to keep your a copy of your certificate. Hopefully you requested one during the registration, and if you are audited by your board, you'll have to present that certificate. So we will be emailing certificates individually to each one of you who requested them after the training. And we'll be checking to see, who logged in to make sure that we're only sending the certificates to folks who actually joined us today. Although we have a really, really good proportion of people who registered joining us, which again, I'm really excited about. If you aren't an attorney and you aren't someone who's seeking CEUs, but you just want a certificate, please feel free to shoot us an email on that. If you haven't already registered and selected that you would like a certificate, we're happy to generate one for you, but we will need a request from you. So you either would have made that request when you registered, or you can make that request now to us via email. And before we get started on actual content, I did want to take a minute, and I think I did things a little out of order, and that's why Sierra jumped off video. But I just wanted to allow Morgan, Leah, and Sierra to introduce themselves more fully and give you a little bit more time with their beautiful faces before they go blank. So go ahead, guys.
Hi, everyone. Good morning. Thanks for joining us. My name is Morgan Keelholtz, and as Elizabeth said, I am the staff attorney in the Southwest region in the satellite office located in Cincinnati. I will be co-presenting with Elizabeth, so hopefully we can teach you a few things and have some fun this morning.
Hi, I'm Leah Williams, and I'm a victim advocate at Ohio Crime Victim Justice Center. I work a lot with Elizabeth in Southeastern Ohio, and happy to have you with us. Just wanted to briefly jump in, and there are some people that cannot see the interpreter box. So I just wanted to make you all aware of that. They can see Elizabeth, but not the interpreter.
Okay, to address that, what I think could be going on, sometimes in your Zoom settings, you may have it focused on only the active speaker. You just want to make sure that in your settings for the video, you can see the entire panel, and that way the interpreter box will stay up for you the entire time. If you turn it on active speaker only, it will only go to the person who is actually speaking, which will probably be myself or Morgan the entire time.
Thank you.
Good morning, everyone. I am Sierra Davis. I am the Northwestern advocate in the Columbus office, and I'm excited to be here today with everyone.
Sorry, I was having technical difficulties with unmuting, but I'm going to turn it over to Morgan to get us started with some introductory material, and we'll also have, as I just accidentally previewed for you, a very exciting pre-test. So I'm sure we're all psyched about that.
So just a quick note on language, depending on what organization you work for or in what field you work in, you may hear survivor and victim used interchangeably. OCVJC uses victim exclusively because it does have a constitutional definition. So we do not switch between victim and survivor. We will always stick with victim because when we go to court, we can say, you know, Your Honor, this person is a victim and here's why and here's how the definition applies to them. And with that, we are going to see how much you guys know about victims' rights from the very beginning. So go ahead and take a few minutes to take this pretest.
If you're feeling very confident as you work your way through the test, let us know in the chat if you feel like I am going to be the envy of my friends and neighbors because I know all of these answers. I would love to see a little conversation and a little friendly competition. Other than caffeine and sugar, that's one of the things that I think can really help people to get through a conversation about the law at 8:30 in the morning.
Sorry to interrupt. Do we know why some cannot respond to the survey? It's not allowing them to send their response.
I think that could possibly be a pop-up setting because the survey technically is a pop-up. I see that we have about 137 people, 39, who have been able at this point to respond. So I think that may be some type of pop-up setting depending on the browser that folks are using. They may just want to check into that. We have had that problem intermittently, but the vast majority of folks seem to be able to participate.
Thank you.
All right, we seem to have maybe all of the participation we may get. I haven't seen an answer come in quite a moment. So typically throughout the presentation, we will share poll results with you, but we're not going to share this one with you because we're hoping that when we take the post test, you're going to recall how you answered and how you felt at the beginning, and you're going to see, as Morgan said, that we taught you something this morning. So we don't want to give away all the answers because what fun would that be? So we will not share the results for this particular poll, but we will be sharing the results for all of the other polls with you and discussing those just so everyone knows what's going on.
Okay, I think this is me still. So we're going to talk through some terminology, victims' access to justice in the Marsy's law history. Elizabeth kind of already touched on this, but we're going to kind of show you what the law used to be and what it is now, and what it might be soon. So we're going to talk through all of that. So just a note on access to justice for crime victims. A lawyer should be mindful of deficiencies in the administration of justice. Therefore, all lawyers should devote professional time and resources and use civic influence to ensure equal access to our system of justice for all those who, because of economic or social barriers, cannot afford or secure adequate legal counsel. So OCVJC provides all no-cost legal representation to victims. We do not have an income cap like some nonprofit organizations have. If a victim comes to us and needs our assistance and we believe that we are able to help in that situation, we are going to help them regardless of their income situation. This is really important to us. We do see a lot of victims that come to us with, hardly anything at all, especially in situations where the crime may have depleted them of any money or possessions that they own. So everything we do here is no cost. We also do work some with pro bono attorneys for referrals, depending on the situations, if for some reason our grant restricts us from assisting in some way. So we just like to point out that it's really, really important work to do that pro bono work, and that we believe here that everybody should be able to get the assistance they need regardless of their situation. So what is Marsy's law? Well, we're going to talk about it for 4 hours today. So I guess we better just explain what it is now. It is a constitutional amendment. It was passed back in 2017 with 83% voter support, and it went into effect in February of 2018. It is in honor of Marsy Nicholas, who was a victim in California. She was murdered by her ex-boyfriend, and her family was not given any notice of what was happening in the criminal justice system as far as charges, stuff like that. They went to the grocery store for what seemed like, just a regular outing to get necessities, and they literally almost physically ran into Marcy's murderer. He had been released on bond, and they had not been given any notice of that. That's obviously very traumatizing, it's devastating, and it's also a huge safety concern for most victims in that situation. So this was obviously upsetting. After this experience, her brother set out to make sure that victims were provided notice and other rights throughout the system to protect themselves and also to make their voice heard. So who is a victim? Well, as I already explained, we use the word victim because it does have a legal definition. Marsy's Law, when it was passed, did expand that legal definition from someone who was directly harmed by the offense to a person who was directly or proximately harmed by the criminal offense or delinquent act. So this broadens the spectrum a lot. Instead of, once Marsy was murdered, was her family a victim? They would be considered a victim under this definition here today, and they would have rights throughout the system. So who is directly and proximately harmed? Parents of child victims would be able to be victims, would be considered victims in the criminal case. Families of homicide victims, as I mentioned, Marsy Nicholas. And then if you guys can think of any others, you can drop them in the chat and you can answer this poll question. This is a select all of the above, not just a one hit. It looks like we may still be having a problem with viewing the interpreter. It looks like you can see me, but nobody else. If you hover over me while I'm speaking, at the top I have a dash, a square, two rectangles stacked on top of each other, and then a grid that has 9 squares in it. If you can see that, if you choose either the 2 rectangles stacked on top of each other or the 9 square grid, that should show everyone. If you do the 2 rectangles stacked on top of each other, we're going to be in a line either on the side or at the top of the screen, and you should be able to scroll to see all of the interpreter and everyone else.
So it looks like the poll results are in. What do you think about this, Morgan? Parents of child victims, 97% of people said yes, those folks are considered victims. What do you think?
Well, I think we told him the answer in the last slide.
I know, right?
So that was a freebie. Family members of homicide victims, I also did tell you that one. Witnesses to a mass shooting, that one's a little more unclear, but they would be considered victims in that situation. So all of the above was the correct answer. The reason we don't give an all of the above option is because research shows you will always pick that one for the most part.
Hi guys, we do have a question. Can there be a victim on an M4 disorderly conduct charge if disorderly conduct is an offense against the peace? Could someone who was present for the disorderly conduct be considered a victim?
I think that's a really hard one. I don't know what your thoughts are on that, Morgan, but I think that that particular question would be very fact dependent on what the disorderly conduct charge was in terms of underlying actions. Because we know from working with victims of domestic violence for a very long time that oftentimes the crime itself is actually domestic violence and it meets the elements of domestic violence, but ultimately the case may end up pled down to disorderly conduct. So I think if you were talking about a scenario where something like that occurred and you had children who witnessed the domestic violence incident that ultimately gave rise to that conviction for simply disorderly conduct, we would argue that those children were victims. However, disorderly conduct as a charge has a broad spectrum of different activities that could give way to that charge. I had a friend in college who drank too much and would not stop hugging a stop sign. He got charged with disorderly conduct. So I think it really is dependent upon the underlying facts. And if you have a case where you think that there is a victim, but law enforcement or prosecutors are not treating the case as if there is a victim, please reach out to us. Our advocates and attorneys are more than happy to workshop cases with you and, give you kind of our position and what we've seen in terms of what type of facts in those more gray scenarios would give rise to someone meeting that legal definition of victim. And Morgan, you can chime in at any point to add or disagree.
I think you covered that one. So moving on, if we don't have any other questions regarding who can be a victim at this point. So how does a victim exercise their rights? They can do it a multitude of ways, and they don't have to stick to just one way. So they could do it pro se. Obviously, as attorneys, that's not usually what we suggest. But
Morgan, what's pro se?
That means that they can represent themselves and their interests in the courtroom. Like I said, as attorneys, that's normally not the one that we would suggest. But if a victim feels that they have a good handle on what their rights are and that they can communicate those to the court, then that is their right. They can do it through counsel, which would be somebody like Elizabeth or myself or one of our other attorneys at OCVJC. They can do it through a representative. So that would be like a parent representing a child's interest when the child is the victim of the crime, or a friend could represent them in their interest, a mother, a father, any family member. But obviously, or they could use an advocate. We have advocates at OCVJC. They are not licensed attorneys, so you have to be mindful of the prohibition on authorized practice of law if you have somebody who is not an attorney practicing in the courtroom in that capacity. And then through a prosecutor upon request, this gets a little tricky sometimes. We have quite a few victims that come to us saying that they have an attorney, or they have a misunderstanding of the prosecutor's role in the courtroom. So prosecutors, first and foremost, have to represent the interests of the state. They have a duty to represent the interests of the state, not the victim. Now, if the state's interest and the victim's interests align, and the victim wants the prosecutor to advocate on their behalf, then they can do that. But sometimes, when it comes to different things, whether or not it's that the victim wants to be present for the entire trial, and maybe the prosecutor doesn't agree with that, which we'll get into that later, but just as an example, then that's something where the prosecutor would not be able to properly advocate on the victim's behalf because they have a different interest that has to take precedent. So those are just a few ways that they can exercise their rights in the courtroom. Again, obviously, if we're involved, the way that they're exercising their rights is likely through counsel. but they can still have a representative. They can designate a representative on behalf of them as well. So what are victims' rights? They are, they have several rights, and they start at the very beginning of the criminal justice process, and they come from several different places. So Ohio state and federal crime victims are going to have different rights depending on the situation at the hospital, investigation, then the prosecution, and post-conviction stages. And here is a list of where all of these rights come from. Obviously, when we are practicing in the courtroom, we're always going to cite to the constitutional right if one exists. There are statutory schemes that have been in place for many, many years. They were mostly ignored for the majority of the time until the constitutional amendment passed. But they are there, and we do cite to those as well. There's case law. Ohio finally has, some good case law on victims' rights, and we also use case law from quite a few other states that are a little further ahead of Ohio on kind of defining their constitutional amendments. There are administrative regulations, which Elizabeth is going to talk more in depth about at the hospital stage, court rules, and then the Department of Health protocols. So that's just a list of everything. We're going to break those down and kind of show you where everything is and how we would argue certain things once we get further into it. This is really just the intro. And here's a note on the previous constitutional amendment from 1994, and all it said was that it guaranteed victims the right to be treated with fairness, dignity, and respect. All of the lawyers are on here are probably like, that doesn't mean anything. Those are just some pretty legal words, and we would agree. There was really no definition of what that meant. And so obviously the revised code section and the constitutional amendments are really helpful in defining victims' rights more thoroughly today. As a starting point, go ahead, sorry.
Sorry to interrupt you guys. We're just trying to work out the interpreter situation. Is there a way to spotlight our interpreter? They're saying that the presenter needs to spotlight the interpreter in order for them to view her. It's actually, it's something that the host has to do.
So I went ahead and did that. That may, just so you know, and folks can let us know if this happens, that may make it so that you can no longer see Morgan and myself, which, speaking for myself, I'm fine with. But just let us know, because I did select Spotlight for Ashley, our interpreter, right now. So hopefully that resolved the issue without creating another issue, but please keep us posted as to what folks are seeing there.
Thank you.
Okay, great. So back to the neurobiology of trauma. This is a link to a video. I think it's about 90 minutes long, maybe. And it is Rebecca Campbell. She is a psychologist who talks about the neurobiology of trauma. And as a training, when we all began at OCBJC, we were required to watch this. It's super helpful in explaining what a victim may be going through, and it explains kind of some actions that may seem irrational or not make sense to you after they've experienced trauma. She essentially explains trauma as, this very traumatic crime just happened to them, and then you have Post-it notes of all the details of everything that happened, and you just kind of throw them in the air on the messiest desk, and then you're trying to piece that story together. So this is especially important for people working with victims to understand, and even more so for law enforcement. It's going to help explain why maybe there's just pieces of the story missing. You know, your your reaction might be, you know, they're lying to me, this doesn't make sense, they keep changing their story, but really it's because they can't make sense of what just happened to them. Their brain is the messiest desk ever, with post-it notes and thoughts all over the place that they are trying to piece together all at once. So this is really going to help law enforcement when they're interviewing a victim of a crime, and trying to get that full story, to kind of sit back and, you know, wait with them, let them think about it, help them think through it, kind of step by step, because, you know, law enforcement knows if you do have all of these contradicting stories coming from a victim, that can affect prosecution down the line. It can affect the trial if it gets to that point, when they have all these different statements that don't exactly line up. So this is just a really good start. It's a very basic explanation of how the brain works after it has just experienced immense trauma. So this is a note from the previous constitutional amendment. It explicitly denied victims the ability to appeal any rights violations. So if a victim were to exercise their rights in the courtroom, those rights were violated or denied, that is basically where their enforcement ended. There was no way for them to appeal that decision. So it was kind of a lose-lose situation for them. Marsy's law really changed that for them. You know, it gives victims the due process rights to fairness and respect for victims' safety, dignity, and privacy. They also have explicit standing, the ability to be represented by counsel, and the right to appellate review. So before Marsy's law, which I was not here then, so I've had the easy road, I guess. But Elizabeth can talk more about it, but they used to have to fight to have standing in the courtroom when they would go to court on behalf of victims. They would have to argue that they had a right to be there and that victims have rights and that they should be able to exercise them. Now we don't do that. Victims do have an explicit right under Marsy's law. I have never had to argue standing in the courtroom. You know, I just enter my notice of appearance and file whatever motion the situation calls for. And I've never had to fight my way into the courtroom, essentially, in this position. The right to appellate review is also a big one. Obviously, that helps a victim to be able to assert their right if for some reason the judge, you know, says he doesn't believe in Marsy's law, or he disagrees with it, or he doesn't understand it and doesn't, you know, he makes a decision that is violating a victim's rights. They do have the right to have review of that.
Yeah, I'll just throw it out there. As Morgan said, my experience has been a little bit different from hers. I've been here a little bit longer, just a little bit. And I will say that I can't overemphasize how much more difficult it was for us prior to Marsy's law. We ultimately were able to get the job done, but more than once I would show up to court with my client to try to ensure that their rights as a victim were going to be protected and enforced. And the actual courtroom door was locked. I mean, it doesn't get more literal than that in terms of a court sending you a message that they don't want you to be there, other than locking you out. And so, you know, once they unlocked the courtroom door, which they always eventually did, we would have to make the argument, as Morgan said, that we even had a right to be there. So think of it as your foot in the courtroom door. You know, this is, I can even fully walk into the courtroom and be heard, let alone the merits of the underlying victims' rights issue that we're here to address. And so for Marsy's law to provide us with explicit standing has basically unlocked those courtroom doors for us and for our attorneys and for the victims that we serve. And as Morgan kind of mentioned in the beginning, and we'll be sharing throughout this presentation, in these past few years, it's given us kind of the stepping stones that we need to create positive case law for crime victims in Ohio on some issues for the very first time. And so we're very happy about that, and about the ability to seek appellate review. As the attorneys on the call will be aware, you can have a win in trial court, but we have hundreds of trial courts in Ohio. So to have a victory for a victim and for other victims who are in a similar situation truly kind of reverberate through the process, you need to be able to get up to those appeals courts. It's very difficult to win a trial court issue on the same issue in 200 courts. And that same thing can be accomplished by a victory for crime victims at the appellate level or the Supreme Court level. And so we'll share more about that with you. But I think that this particular provision of Marsy's Law for me has been most impactful, because this has given us the ability to even get our foot in the courthouse door to make the arguments that we need to make for victims.
So our first practice pointer, and we will do these throughout as well to kind of show you how we practice these rights. But since the Constitution, the wording in the Constitution allows victims the right to petition the appellate courts. So regarding appellate review, the only case law in Ohio currently is from the 8th District, and it says that victims should seek appellate review through complaints for writs. So essentially, they took out the option for a victim to file an interlocutory appeal, and instead said, no, this should be an extraordinary writ.
What's an extraordinary writ, and what is an interlocutory appeal?
So an interlocutory appeal would be an appeal based on a decision before the case is all the way over. And an extraordinary writ can be in several different forms. It could be a writ of mandamus, a writ of prohibition. Those are the two that I'm most familiar with because I've practiced those. Do you want to jump in?
Sure. So, and Morgan, I'm sure you'll back me up on this, and any other attorney on this call will probably back me up on this as well. When you're in law school, they talk really briefly about extraordinary writs, and then they kind of say to you, don't worry about these. You're never going to use these in real life. This is just something that you might be on the bar exam, and then that part of your life will be over and that chapter will be closed. Well, in victims' rights in Ohio, especially right now, this is kind of all we're using for the most part to seek appellate review right now. And I think the distinction, the easiest way to understand it, an appeal is a part of that underlying criminal case. Whether the appeal is interlocutory, meaning you take the appeal while the underlying trial level case is still ongoing, or if it's an appeal after the trial level case has concluded, it is still a part of that case. So the victim is filing something as a third party in a case that is titled State of Ohio versus John Doe criminal defendant. An extraordinary writ is very different because an extraordinary writ, it is victim versus judge who has denied the victim's right. And it's a very different action in that way. And it's called an original action because these cases often start in an appeals court and have the appellate review then actually comes from the Ohio Supreme Court. So while we wish that this 8th District decision was broader and allowed victims all of the avenues of appellate review that we feel they are constitutionally entitled to and that other folks are entitled to in Ohio, including parties to a case and also third parties, we do like the fact that using this route through the extraordinary writ gets us to the Ohio Supreme Court quicker than if we started in another way. And so we do have, I think, an opportunity here, and we have been taking advantage of that opportunity to make and change case law for the entire state so that all of the literally 1/3 of a million people who are victims of crime in Ohio each year can benefit from the cases that we are litigating. So, as I said, this decision, in my opinion, is very limited. I don't agree with it. It's a very strange decision for attorneys in the sense that a 3-judge panel made this decision, and the one judge felt one way, 2 judges felt a different way, but somehow the one judge was the winner and wrote the majority opinion that's now the law. It's very confusing. And as I said, we don't agree with all of the rationale behind it, but it does present some unique opportunities for victims that our office and other organizations like ours are capitalizing on. So we're going to talk primarily today about state court rights. And when we talk about Marsy's law is in the Ohio Constitution. So the only law in Ohio that would be higher than the Ohio Constitution would be the United States Constitution. And just for your edification, there are no victims' rights at this time in the United States Constitution. So basically, victims in Ohio have some very significant state court rights. The vast majority of our practice takes place in state court. We'll spend just a couple of minutes briefly touching on federal court rights because we do sometimes litigate cases in federal court, and just know that the rights are substantially similar. But we're going to spend a lot of time in Ohio today. So as we get started, before I jump into this conversation about the hospital, just some things to kind of reflect on. These are common questions that we get from most victims when they come to us. And we'll have victims approach us and seek our services sometimes before they've even filed a police report. Other times when they're actively in the prosecution process, other times when they're struggling to understand what's happening with the investigation of their case. But they all have the same primary concerns, and really those concerns are about safety, privacy, and frankly, continued employment. So in terms of safety, we have a lot of laws right now on the books, both in the Constitution and the Ohio Revised Code, that are going to provide victims substantial safety rights, and we have to help them engage those rights and make sure that their rights to safety are being protected. Sierra, I see you. Yes.
Yes, we have a question.
Sure.
Could this apply to families of people killed by police appealing their decision to acquit offenders?
Okay, that's a great question. So I see that as a 2-part question, so I'm going to answer that in 2 parts. One, could folks who are killed by police be considered victims for the purposes of Marsy's law and these other rights that we're going to talk about today? Yes. Yes. There's nothing. If you are a victim of a crime, regardless of who commits that crime, you are going to be entitled to the Marsy's law rights and the other rights that we're going to talk about throughout the course of this discussion today. The second part is more difficult because you're talking about appealing an acquittal. That is a very specific fact circumstance, and you bump into some very large United States constitutional concepts when you talk about something like appealing an acquittal. So when someone is acquitted, that means that a jury has found them not guilty, right? And we have this prohibition in the federal or the United States Constitution on subjecting someone to double jeopardy. So once a jury has found that someone is not guilty of a crime, neither the victim nor the prosecutor can appeal that acquittal. Now, if something goes procedurally wrong that leads to the acquittal, the prosecutor has a limited ability to appeal and say, going forward, we need to make sure that this judge doesn't continue to do this, and get kind of an advisory opinion from the Court of Appeals that says the judge made a mistake in this case. We're not going to do anything because this person was acquitted, and that's the end of the line. But going forward, the judge should be more mindful and not do something like this again. But the short answer is no. Once someone is acquitted, there's really nothing that can be done at that point. Now, what's more common in these types of cases would be where law enforcement is never charged with a crime and there's never an investigation, or there's an internal investigation, but the results of that are not released to the victim's family. In those type of situations, you can absolutely advocate for access to those records of that investigation, to speak with prosecutors on, why that case isn't moving forward, and try to get that case moving forward. But once an acquittal occurs, you're at the end of the road. Yeah, Morgan.
Can you change the spotlight to Stephanie, our second interpreter, please?
Absolutely. Stephanie, you're now in the spotlight.
Thank you.
So, do we have any other questions at this point while I'm on my roll? All right. I'm not seeing anything, but please feel free, Sierra, Leah, Morgan, any of you, interrupt me at any point. So safety, right? Victim safety, very key. We need to let victims know that there are laws in place to protect their safety, and make sure that they understand that we're going to do everything that we can as advocates or attorneys to make sure that their safety is considered and protected. Privacy is another big one. And as Morgan said, one of the new constitutional guarantees of Marsy's law is this explicit right for victims to privacy. And, for us, one of the things that we argue that privacy means is allowing victims to seek redaction of their names and identifying information from public record. We've had numerous cases where really sensitive information about crimes has been publicly released and has been very upsetting, as you can imagine, for our clients. And so we really have been advocating that this new constitutional right to privacy must include the ability of a victim to seek redaction of their name and identifying information from public record. But there's so much more to privacy than that. Privacy is a right that victims have from the time that the crime occurs all the way through post-conviction, and the possible incarceration of an offender and release from incarceration. That privacy right persists and will come into play in a lot of different ways, and we will always be there to make sure that the victim's privacy is protected. And then finally, and maybe most concrete, is the fear of a lot of victims that they're going to lose their job if they engage in the criminal justice process, because they know there are going to be continuances, there are going to be hearings, there are going to be meetings, there's going to be a lot of involvement on their part with the criminal justice system. And, we work for an organization, and a lot of folks on this call probably work for an organization where if you wanted to be involved in the criminal justice system to protect and enforce your rights, your boss would be cheering you on. But not all of our clients are in that situation. And as Morgan said when she was talking about access to justice, a lot of the folks that we serve are low income folks who are really living paycheck to paycheck, and we need to go to the mat for them to make sure that their jobs are protected. And there are laws that we're going to discuss through the course of this presentation that will help us do that. All right, so let's jump into the hospital. And at this point, before I start, I'm going to ask all of our attorneys on the call now to go ahead and send a chat to panelists, all panelists, with your name and your attorney registration number so that we can record your attendance and participation at this point. So please go ahead and do that. When we talk about rights at the hospital, we are primarily talking about the rights of sexual assault victims and domestic violence victims. There are some other minor statutory provisions that deal with felony level assaults. So things like aggravated assault, felonious assault, which typically involve pretty significant injuries. But for the most part, we're talking about administrative regulations, as Morgan mentioned, that provide guidance and best practices to our hospitals on how victims should be treated when they report to the hospital for treatment. So the first thing that I always like to bring up before, and it's so timely because we have our wonderful interpreters with us today, and now I've made them talk about themselves and they're probably feeling weird about that, but is ensuring that folks who are deaf or hard of hearing or non-English speaking or limited English proficient have interpreters at the hospital. And I like to talk about this in two different ways. And one of the ways is kind of ruthlessly pragmatic, and the other way is how I feel. So I'll start with how I feel. I feel like, and I know from my experience, that it is very damaging to a victim for the first interaction that they have in the aftermath of a crime to be a confusing interaction where they feel unsupported. When we don't provide interpretation services, or we don't provide adequate interpretation services, that is almost always disastrous for a victim, for their healing, and for their willingness to continue to engage in the criminal justice process. On the pragmatic side, when victims first report to a hospital, especially for sexual assault, they're going to be making a statement to the medical personnel, typically a doctor or a sexual assault nurse examiner, about what happened. And if we can't effectively communicate with that victim, we will end up with a statement that makes no sense, that puts us on an uphill trajectory to try to get that case moving forward. We have had numerous cases over the years where hospitals have said, yes, we're located close to a college. We have all of these wonderful Spanish-speaking students or French-speaking students or German-speaking students at this college. Let's just have one of these students come over and provide interpretation services. I would discourage that. Interpretation services really need to be provided by somebody who has a fluency, a command of the language. When victims report to the hospital, the things that the sexual assault nurse examiner or the doctor are going to share with them are going to be very medical, and they're also going to be very legal. So you're getting two complicated topics that it's hard enough for most of us to speak about and understand if we're native English speakers, and now you're adding the added issue of poor interpretation services. And that is going to create, like I said, a statement that in some cases is absolutely nonsensical. One of our clients had the really horrible misfortune of having both the hospital interpreter and the law enforcement interpreter be folks who are not fluent in her language. And ultimately, when we got to an interpreter who understood these legal and medical concepts, this interpreter looked at the statements and said, these literally do not make sense. I cannot make sense of this translation or this interpretation. And, you know, that created a lot of problems, and it creates a lot of problems for a later prosecution when you have nonsensical statements at this early point. So please, please, please advocate for victims that they have effective, competent interpretation services at the hospital to ensure they have effective communication. As I said, horrendous results for victims in their healing, and then horrible results for the criminal justice process as a whole when we're not providing that. All right, now, instead of giving you the answer first, which made it clear to me that we need to rearrange some of our slides, we're gonna have you actually take a poll on which hospitals have to provide a sexual assault forensic examination kit collection. So please weigh in on that. And again, I would like to encourage healthy competition. If people want to get, you know, a little bit of friendly conversation going back and forth and tell us how you feel in terms of your confidence level of how you're doing with these questions, we would love to just have some additional interaction with you. It's as weird for us as it is for you that you have just talking heads for 4 hours. So any type of interaction that we can get with you, we're very grateful for, and just appreciate you taking the time to do so.
And if you have questions, we encourage you to ask them live. We do not save any time at the end for questions. We can talk and talk and talk and talk, as most attorneys do. So please feel free to drop some questions in the Q&A for us to answer live if you have them. Don't wait and save them till the end.
let's just all be honest about who we are as people. If we wait until the end, it's going to be 12:30. I don't know about you. I'm going to be very hungry by then. All of us are going to be thinking about DoorDash or, if you're me, eating Lucky Charms or something like that. So, please, as Morgan said, ask any questions that you may have. All right. It looks like the results are in, and 66% of people said all hospitals. 21% said only hospitals that offer emergency services, and 13% said no hospitals are required to provide these services. So the vast majority of you think that all hospitals should be providing these services. And I agree with you, but that's actually not correct. The law, and this is not an administrative regulation, this is actually the Ohio Revised Code, specifically provides that only hospitals that provide emergency services have to have someone available 24 hours a day, 7 days a week to provide a sexual assault forensic examination and to collect the evidence kit, or sometimes called the rape kit, which is ultimately sent for the DNA testing. So I have a little sub point here. Oh, looks like we're sharing results again.
I'm
Sorry
concerned
about
about
that.
the people that don't think any hospital has to provide a SANE kit. I'm concerned about where they live. What does that mean for them if none of the hospitals in their area provide a SANE kit? What does that mean for a victim?
Yeah, thank you, Morgan. I think that's a great question. And as Leah said, she and I work together in the Southeastern Ohio region, and I'm from Southeastern Ohio, right on the river. And I know that while we do have some local hospitals that provide emergency room services, we also have hospitals that do not provide these types of services to victims. And, I can't help but think about the folks that I grew up with, very blue collar folks for the most part, people who, may be working at a restaurant or a small shop, or they may have their own business. And for them, you may have a family with only one reliable vehicle. And sometimes the message that they are given when they report to the hospital after a sexual assault is, you're going to have to drive to Columbus to get that type of treatment, or you're going to have to drive to Columbus to get your child this sexual assault forensic exam. And, you think about it in terms of the math, right? If I appear at the hospital at 1 a.m. because I've just been sexually assaulted, and now I'm being told I've got to drive to Columbus from Southeastern Ohio, okay, that's a 2-hour drive. When I get to the hospital, are they immediately going to whisk me in a room, or am I going to be waiting for a minute? How long am I going to have to wait for the nurse? When the nurse shows up, how long is this going to take? And the reality is, this exam, which is very in-depth, because the sexual assault nurse examiners especially do a fantastic job, but you're talking about somewhere between 3 to 6 hours. And then I have to get discharged, I have to drive home, and I have to work. And when we put those types of barriers in front of victims, we end up with a scenario where a lot of people are not reporting these crimes because we've created these barriers that make it impossible for them to get the services that they need.
Elizabeth, we have a question from Lauren. She wants to know, if you have several hospitals in the area that are not providing SANE exams, how do you correct that? She has 2 hospitals in her area that offer emergency services, but still refer to another hospital for SANE exams. And she had a victim that refused to go to another hospital because it was obviously an awful and traumatizing time.
Yeah, absolutely. And I wish I had a magic wand to wave to solve this problem, because it is a problem, and not just in our rural areas either. I don't want to create that perception. We have a lot of these same issues in the city, where we have more hospitals and we don't have as many hospitals providing this service as we really should have. One of the things that I do, if we have a client who comes to us and lets us know that this happens, I will reach out to the hospital, probably through their legal counsel because I'm an attorney, and I will say, are you aware of your hospital's obligations under the Ohio Revised Code? I may also reach out to the Attorney General's office. If Sandy Hunsinger knew how much I say her name in these trainings, she would probably send me a mean text message. No, I'm just kidding. She would love it. But Sandy Hunsinger at the AG's office does a lot of training and works a lot with hospitals to try to remedy these issues. So Sandy would definitely be one of my first calls as well. If you have a local hospital in a small town, I know in the town where I grew up, I can just drive up there and talk to somebody that I may know because they may be a family friend and be like, come on, what's going on? So really leverage those relationships. I try to give folks the benefit of the doubt when I can. And, I want to believe that they're not purposefully ignoring the Ohio Revised Code, but instead they are not aware of their obligations under the Revised Code. So my first conversation would always be, are you aware of this? What can we do to facilitate this? And I'll let them know. Nationwide, sex crimes reporting is 35%. That's abysmal. That means almost 2/3 of people who are sexually assaulted are not telling anyone. They're not reporting it. And I think a big stumbling block for that is this initial reaction or interaction with a hospital. And so bearing that in mind, making them aware of that reality and the contributions that they may be unwittingly making to that. I know some hospitals who don't provide the services will at least provide transportation to a near hospital that does, and that should be free because you are, kind of shifting off onto that other hospital, your obligation under the Revised Code. But, the flip side of that, which is my little sub bullet point there, is the problem when we try to force a hospital that doesn't provide these services to provide these services and the outcomes that can create for victims. I had a client once, and it was when I first started this job, and this case will always stay with me because I was very upset and troubled by it. But this particular client actually did everything we would ask a sexual assault victim to do. She was sexually assaulted in her home. She escaped from her home. She got in her vehicle. She drove. She called 911 while she was driving. The 911 operator advised her to go to the nearest hospital. Here's where it is. We're going to send law enforcement your way to meet you there. And when she showed up to this hospital, she was told, we have a sane nurse on call, but this sane nurse works for a couple of different hospitals, which is kind of a setup that a lot of hospitals have that seems to work well for them. So that's one tip, by the way. If you're in a relatively rural area, like I'm from southeastern Ohio, Athens is about 30 minutes north of us. I think some of the nurses from Athens may come down to that southeastern part of the state to provide services. So try to make that type of an arrangement. In any case, that's what this victim was waiting for. Ultimately, the same nurse was hung up. She wasn't able to come in. And the hospital felt that the victim had waited for about an hour and a half or 2 hours. That was too long. And so they got an emergency room doctor. And unlike the sexual assault nurse examiner, this doctor had no training on working with victims of crime. And for those of us who work with victims of crime, we know how crucial those initial interactions are. And we know, as Morgan was sharing, the impact that trauma has had on that person. And we know that we need to act according to that understanding, but this doctor did not. And as he was leading her back to the room, he put his arm around her, which in and of itself, Morgan's face says it all, if you can see that. In and of itself, that's problematic. You don't want to be touching people without their consent ever, just as a general being alive type rule, but especially not someone who's just been sexually assaulted. And then he turned to her and said, maybe if you had made better choices and not invited someone over to your house, this never would have happened. Well, that victim immediately left. She did not have the evidence collected. She did not have the exam performed. She ran back to her car. And the truly horrific part of this story is the impact that that doctor's statement had on the case and on the victim. Of course, she felt disbelieved. She felt unsupported. She completely became skeptical of the criminal justice system, of course. And ultimately, when they caught this offender, he said that he didn't know who she was. So if they had been able to collect any DNA evidence from her body in the immediate aftermath of that sexual assault, this individual, this offender, would have been successfully prosecuted because he went with the story of not knowing who she was. Unfortunately, because no DNA was collected, it was a much, much harder case that ultimately was not successful. And I think that's really the difference between a victim having a positive first experience and having a really detrimental first experience. So we're always walking that tightrope of trying to hold people to their constitutional and their statutory obligations, while also making sure that we don't inadvertently create a very bad experience for victims by forcing people to do things that they don't want to do. And so I appreciate the question. It comes up a lot. I think it's very complicated. If you have a case like that come up, please feel free to reach out to us. We will do whatever we can to advocate for that victim and for other victims in your region as well.
Elizabeth, we have another question. It's a little more broad than just specific to the hospitals. But Tanner would like to know, what is your response to criticisms of Marsy's law disrupting a criminal defendant's due process rights and presumption of innocence, especially when it comes to a victim's right to withhold evidence/discovery? I'll let you go and then I'll chime in.
Oh, Tanner. I have a response. We'll get a little ahead of ourselves on this one, but I'm okay with that. We can go out of order a little bit. Just remind me when we do get to this slide that we have covered this, because this will be a longer conversation. So first, the criticism that Marsy's law or victims' rights could somehow impair defendants' U.S. constitutional rights to things like due process, fair trial. So the United States Constitution is called, and they teach you this in law school, and it's really fancy. You guys are so lucky to be here and here. No, I'm just kidding. The supreme law of the land.
Before you get too deep, can we repin Ashley, our second interpreter, please?
Absolutely.
Thank you.
All right. So the U.S. Constitution is the supreme law of the land. If you have a constitutional due process right from the United States Constitution, fair trial right from the United States Constitution, the double jeopardy right that we talked about, no state constitutional right can interfere with the United States constitutional right. So that's kind of, in my opinion, a fallacy, right? The judge's job in a particular case is to balance and ask the question, is the right to due process truly implicated? Is the right to fair trial truly implicated? And we do have some case law on the right to fair trial and due process that we'll talk about later on, that Ohio courts have already settled, in some cases since the 90s. So the court is going to look at whether those rights truly are implicated. And if the court finds that a victim's exercise of a Marsy's law right, which is a state constitutional right, interferes with a defendant's federal constitutional right, the federal constitutional right is going to prevail, period. That's just how the supremacy clause works. So the specific question, in the way that it was framed as a victim's ability to withhold evidence, there is a Marsy's law guarantee that says a victim does not have to participate in a defense interview request, deposition request, or discovery request. So I like to break that down one piece at a time. And I know that Morgan will jump in here too. For an interview, there has never been in Ohio, even before Marsy's law, any law that states that a victim has to participate in a defense interview. If a victim wants to participate in a defense interview, they are welcome to, but they have always had the right to say no. I think going back to the 70s or 80s, there's case law on that, and that's pretty consistent across the United States of America. So there's never been a court that said a victim not participating in a defense interview is an infringement on a defendant's right to due process or fair trial or any of those typical federal constitutional guarantees that we see raised in criminal cases. Depositions. So kind of the same story here. Prior to Marsy's law, we had really significant limitations on how depositions are used in criminal cases. Essentially, we can't use a deposition in a criminal case unless the witness is not going to be present at trial. And not going to be present doesn't just mean, I'm sorry, I scheduled my vacation. It's, the witness has passed away, the witness is in the hospital completely incapacitated, the witness is unconscious in a coma, or the witness has fled the jurisdiction and we can't find them, we cannot track them down. So in those scenarios, we would be able to use a deposition. So I think when you think about that from a practical standpoint, let's say that you have a victim, and we had a case just like this in Franklin County not too long ago. You all may remember this case, Judy Malinowski, who was soaked with gasoline and set on fire by her former significant other. She was badly injured, and her doctors told the prosecutor's office, you've got to do a deposition if you want to preserve her testimony. She will not live long enough to make it to trial. So that's the backdrop of where we see this type of thing happening, right? So does the defense want that deposition to go forward to preserve that trial testimony? I don't think so. They would much rather go to trial without victim testimony, right? So anytime a defendant wants to depose a victim, but the victim doesn't want to be deposed, chances are the defendant doesn't want that deposition to preserve that testimony. But if the victim does want to be deposed and the defense says, I'd love to depose you, the victim can say, I'd love to participate. You're still going to have to comply with the criminal rules or the juvenile rules depending on the case. And that's going to be a very limited option. But the victim can say yes, and there's nothing in the Constitution that says that they can't. The one that people struggle with the most, and I take it that this question is getting at, is the right to refuse a discovery request. And I think that what we need to understand, and we have to kind of get some language, some agreement on language before we can talk about this. There's a difference in a criminal case between discovery and the other options that a criminal defendant or the state have to get things from third parties. Discovery exists only pursuant to Criminal Rule 16 between a prosecutor and defense counsel. That is the exchange of the information that the prosecutor has in their possession that is exculpatory, that they plan to use at trial, or that falls within another category set forth in the criminal rules. But the key is it's evidence or information in the prosecutor's possession, which includes law enforcement, right? And any state entity over which the prosecutor exerts control in the criminal case. There's Criminal Rule 17, which is a totally separate rule that deals with how you get evidence from a third party. And that is very limited and that is very specific, and that includes a victim. A victim is not a party to a criminal case. We will never advocate for our clients to become a party to a criminal case. We don't want to be. We simply want to exercise the limited rights that were provided by the Constitution and the revised code. We do not want to become a party. So for all non-parties, if you want information or documents from them, you have to subpoena it. And the subpoena process has a built-in protection for that third party, that they can get counsel like us to file a motion to quash, and that motion to quash will trigger an automatic mandatory evidentiary hearing in the trial court. That process has been set forth by the United States Supreme Court and adopted by the Ohio Supreme Court in a case that I think was issued in a decision in 1990. So way before Marsy's law, there has been a process to get things from third parties, and it is not a discovery request. A discovery request from a defendant can only go to a prosecutor. It can't go to a victim. A victim is not a prosecutor. So our position is you've got to keep those two concepts separate. The issue that Marsy's law was made to correct is an issue that we have seen on the rise in Ohio, where defense attorneys don't want to have to go through that evidentiary hearing that they're required to go through when they subpoena a third party. Instead, they want to file a discovery motion and then a subsequent motion to compel to try to force the victim to turn things over as a part of the discovery process. The victim isn't a part of the discovery process. Trying to force them into that process is procedurally incorrect. They have to be, provided the process in Rule 17. And so Marsy's law is designed to say, wait a minute, discovery is this one thing. It's between the defense and the prosecution. If you want to try to use that, no. The victim can say no, because the victim isn't a part of discovery, and they have to be able to say no. My argument would be that way before Marsy's law passed, that was the way the law worked in Ohio. And Marsy's law was only necessitated by some actions of some attorneys to try to circumvent the procedural protections that Criminal Rule 17 provides. So for our position, if a defense attorney goes through the proper procedures, Criminal Rule 17, we'll fight that out. We'll file the motion to quash. We'll participate in the evidentiary hearing. And ultimately, if the court finds that what the victim has is evidentiary and relevant and the defense has met its burden to get things from a third party, we're of course gonna, facilitate that. We're officers of the court. But what we will not do is allow folks to use the wrong process and to circumvent the rights of our clients. And Morgan, if you want to jump in.
Yeah, so just as a side note, also, I don't think that victims are ever trying to withhold evidence or discovery that is super relevant to the case. They want the prosecutor to have all the tools in their toolbox too to present a case on their behalf and hopefully end up in a conviction. That's usually what the victim is looking for. So I don't think that a victim is intentionally trying to take away rights or circumvent due process for a defendant. It's usually, and maybe I'm biased in my position, but it's usually the defendant trying to harass the victim and kind of scare them out of participating in the process. The First District recently came out with an opinion that says exactly what Elizabeth says, and they actually even went to the extent to say that they were not going to address the constitutional victims' rights under Marsy's law and stuck solely to Criminal Rule 16 is only applicable to the prosecution and the defense, the parties of the case. And that's pretty much where they ended it. They did not go into a victim's right to refuse a discovery request in much depth at all. It was basically just a hard stop right there. So the majority of the requests we see that victims do want to refuse are, years and years and years of their mental health records or their private email accounts, or access to their home that their offender who used to abuse them is no longer living in and has been court ordered to remove himself from. Stuff like that, where a victim's safety is going to come into play or their privacy. And like Elizabeth said, if the defense can prove that those are relevant and meet their burden under the Nixon test, then we are not there to stand in the way of their rights to due process at all. We have a few more questions coming in now. Kara wants to know if a victim has a constitutional right not to submit, well, she knows that they have a constitutional right not to submit to a defense interview, but she wants to know if they have a constitutional right to refuse to testify when served with a subpoena. She sees a trend particularly with domestic violence victims who no longer want to cooperate with the prosecution.
Yeah, and so I think that kind of actually dovetails nicely with the conversation about the subpoena, right? Because if ultimately at the end of that process and that hearing, the court finds that the victim does have to turn things over and that is, that does implicate due process, you have a court order that says you have to do it, you have to do it. Same thing with a subpoena from, whether it's from the prosecution or the defense to testify at trial. there is nothing in Marsy's law nor any other victims' rights law that gives victims the ability to ignore a lawfully issued subpoena for testimony, right? So you can file a motion to quash. You can attempt to essentially, a motion to quash is essentially a request from the person, usually the victim, to the court saying, please don't make me do this. But if ultimately the court denies the motion to quash and says, no, you have to come in and testify, or you have to provide these documents, then you would be in violation of a court order if you failed to comply with that. So we do have a lot of, victims who will contact us and say, okay, I don't want to have to testify. And, we can certainly explain, that process. We can talk with prosecutors and share fears that victims may have. I think it is a difficult thing for prosecutors, especially in law enforcement, to wrap their minds around why victims back out for, domestic violence cases and why they may withdraw. And I think that it ultimately does come back to those three questions that we talked about. Am I going to be safe? Is my privacy protected? Am I going to lose my job? Specifically as to safety. I've done training for prosecutors and judges, and without fail, I always get asked a question about domestic violence specifically and victims trying to not have to participate. And it is a source of frustration because folks in the system do want to hold defendants and offenders accountable when they commit crimes. But I think what we have to realize is domestic violence is a misdemeanor in Ohio. Most victims don't know that if someone pushes them downstairs, if it's someone that they're dating, it's probably going to be a misdemeanor, whereas if it's someone that they don't know, it may be a felony. When they realize that the only repercussions are going to be, potentially some probation, maybe some type of court-ordered program, but that the person is going to be released on bond, the person is going to be back in their home, they realize that the system is probably not going to be able to keep them safe. And if they haven't set into motion all of the safety planning and the financial planning that it requires for a victim to be able to safely leave a relationship that includes domestic violence, that's when you see victims withdraw. And I think it's important for us to understand where victims are coming from, but also to understand that these rights that we're talking about do not create an ability for a victim to control the case. They don't get to say, all right, prosecutor, Marsy's law, drop the charges. Marsy's law, I'm not testifying. There's nothing you can do about it. Victims' rights, including Marsy's law, are designed to give victims a voice, not a veto. So this is to make sure that victims are heard and that their rights are considered, but it does not put them in the driver's seat. And as I said, victims are not parties. The state and the defense are the parties. The victim doesn't want to be a party because there's a lot of responsibilities that go with that.
So one more thing, kind of going back to our discussion on discovery and evidence and whether a victim can withhold that, and kind of our take. An anonymous attendee says, so you are agreeing that a prosecutor should not be able to refuse a criminal rule 16 discovery based on Marsy's law. And to answer that question or kind of address it, I guess I'm not sure. I don't think that a prosecutor can refuse to participate in discovery if it's requested. However, if the defense is asking the prosecutor to go obtain something from the victim, then that's where the victim would have a say. That's where Marsy's law would come in. The prosecutor, if he has something in his file, he or she has something in his file that you've requested discovery and they need to turn that over, then that is what it is. But as far as discovery, it, as Elizabeth already explained, it's what is in the possession of the prosecutor, easily obtainable information. So, a prosecutor is not going to have access to the victim's private emails or mental health records or their home for pictures, those examples that I gave. Elizabeth, feel free to add on.
Yeah, no, I completely agree with that. We often caution our clients about prosecutors' Brady obligations around exculpatory evidence. And, don't give someone your counseling records just because you think on one day you explained the case particularly well to your counselor, because your counseling records really are not relevant. Um, Once it gets in, I don't think anyone can disagree. If something is in the hands of the prosecutor and it is exculpatory, they have a Brady obligation to turn that over. I would say, as Morgan said, we've seen a lot of cases where defense attorneys file motions for prosecutors to basically be court ordered to go get things that are not easily obtainable. Medical records and counseling records are protected by privilege. Your emails are absolutely protected by the constitutional right to privacy, the Fourth Amendment. There's a lot of case law on that, even from the Supreme Court. I'm going to go ahead and change our spotlight while also talking. Perfect. So basically, we can't be forcing prosecutors to go out and get things that they don't have. I think all of our courts agree with that. But in terms of turning over things that they do have, I don't think anyone would disagree that that's a Brady obligation. And I would say that prosecutors can invoke victims' rights upon victim request. That's specifically set forth in the Constitution. So if you have a victim who doesn't have counsel, and you have a defense counsel who is asking the prosecutor or asking the court to order the prosecutor to get the victim's counseling records and to bring those into the prosecutor's file and ultimately turn them over, I think that the prosecutor could absolutely invoke Marsy's Law in that limited scenario. Let's get back to the hospital. All right, so we'll try to get through this. I know we're running a little behind, but I do appreciate the questions. Tanner, you didn't know it, but you brought up my absolute favorite thing to debate. I have often had defense attorneys who come to our trainings come up to me afterwards and be like, I would love to debate you on this. And I'm like, schedule it. I would love to. I really enjoy these types of conversations, albeit one-sided, because unfortunately all attendees can do is type in a box. But I really appreciate the discourse and being able to discuss some of these things. So thank you for bringing that up. Anyway, back to the hospital. All right, so something that victims are often confused about is when they report to the hospital in the aftermath of a sexual assault, what the time frame is in terms of the collection of DNA. So in Ohio, what our scientists who collect this DNA have found, primarily scientists for the Bureau of Criminal Investigation, which is BCI, is that when you have a child who is 15 or younger, the prime time to find DNA on that child, whether it's DNA from bodily fluids or touch DNA, which is from actually touching someone, is going to be within 72 hours. If you have someone who is 16 and older, you're going to have 96 hours. We get a lot of questions as to why. Why is there a difference in timing? And I think what it comes down to is children are more active than adults, right? Like I'm sitting here in a chair in my guest room office talking to you all, and I will be until about 1 o'clock. You all will be sitting in a chair in your office somewhere listening to me talk. None of us are out right now because we're out of school climbing trees, riding scooters. We wish we were, but we're not. We're stuck here. And, children just tend to be more active, which can degrade DNA. And then on top of that, a lot of times with children, we do know that offenders are in the home. And so the ability to, decide when the child's going to take a bath, when the child's going to brush their teeth, they don't have the same agency around decisions like that as adults do. And so they have a slightly briefer time period. The one thing that I would note when you're advising victims about this, when they're outside of this time frame, the hospital probably won't try to collect DNA unless there's some type of extenuating circumstance. They can still perform the exam. They can still check the victim for injuries, document injuries, take the photos, fill out all of the paperwork. Just because they're not swabbing for DNA doesn't mean they can't check for injuries and document injuries and for that to become a part of the case ultimately. If you have someone who is over the age of 18, so it must be an adult, you have the ability to submit an anonymous kit. Essentially, this is where only the hospital knows the identity of the person submitting the kit. This is a choice that some victims make when they are less than sure that they want to go forward in the criminal justice process, but they know they want to preserve evidence in case they change their mind later. So it's very, very important. One of the first things that hospitals will do if they have an adult patient is let them know about this option. And what I have found just anecdotally from working with SANE nurses for about the past 7 years, a lot of victims who initially want an anonymous kit will change to be identified by the end of the exam. And I think that that speaks to really the experience that a lot of our sexual assault nurse examiners are providing to victims, and the faith that sexual assault nurse examiners can create in the criminal justice process, by believing the victim, supporting the victim, providing resources to the victim. So while a lot of kits may start as anonymous, we never know that ultimately because victims may change their mind by the end of the exam. When you're talking about minors, they do not have the ability to do an anonymous kit. So that is mostly hinging on the mandated reporting law that we have in Ohio that says most professional people are mandated reporters of child abuse, which of course is going to include child sexual assault. Minors can consent to kit collection without a parent though. So if you have, in most cases, a 12 or 13-year-old victim, because the offender is often in the home, the hospitals have acknowledged that, and they've put this policy in place that at a certain age, they will allow the informed consent for the treatment to come from the child. And so that's very important. If you are a trusted adult, you should be able to bring the child into the hospital for that treatment, for that kit. The one caveat to that is that hospitals, most of them have a policy that they will notify parents after the exam to say, hey, your child was in today, this happened. So this is a moment where it's so crucial that law enforcement who may be present and the hospital personnel who are working with the child victim really establish a rapport with the child victim so that the child victim feels safe to disclose who is hurting them, so that we don't inadvertently put them in a very dangerous situation by sending a letter to a parent who is actually the abuser.
Elizabeth, we have a question.
Sure.
Is there a minimum age for a child to consent? I assume the consent is to the kit being collected.
Yes, so every hospital is a little different, but from around the state, what I have heard is 12 or 13 years of age would be the minimum age. So if the law enforcement officer who may be present and the medical personnel kind of build a rapport with the child discloses that the offender is in the home, law enforcement can tell the hospital, under no circumstances should you mail a letter to the offender to say that the child was in for this exam. And the hospital is allowed to comply with that instruction. As a side note, because hospitals require informed consent, parents can't force their children to submit to collection of kits. We've all heard horror stories about parents who want to see if their child is sexually active, and so they want to bring them in to have them examined. That's not ideal and also impermissible under these regulations. There's the ability of all victims to seek a drug-facilitated sexual assault kit. So if a victim feels that the sexual assault was facilitated by what we commonly refer to as a date rape drug, there's the ability to do testing for that. For most hospitals, a complete panel of testing is off-site. So they'll send out the blood or the urine from the victim. I always warn clients about this because the reality of date rape drugs is that they are in a person's system for a very brief period of time. So if it's been more than a couple of hours since the sexual assault, the chances that that drug will be found are probably not great. And of course, then the victim puts themselves in a position where they've said they think that they were drugged. They've, sent out for the kit to prove that they were drugged. The kit comes back with no drugs in the victim's system. And then later on, when there's a prosecution, there's this appearance that the victim lied or the victim was wrong or the victim made this up. The other issue with drug-facilitated sexual assault kits is that they will turn up all of the drugs. They don't just test for common date rape drugs. So if you have a victim who is a recreational user of something like marijuana, that can come back in the DFSA and could be used later on to basically impeach that victim's credibility at trial to say, well, they're a drug user, their perceptions are skewed, they're a criminal because they were on drugs at the time, voluntarily taking these drugs, things like that. So for me, it's a very difficult decision when I'm providing guidance to a victim on whether we should pursue this. And we really have to see all the stars align before I feel it makes sense. And there's also the financial costs, one of which could be the cost of the drug facilitated sexual assault kit. That could be an out-of-pocket cost for a victim in some jurisdictions. So there are certain costs that are covered by the Attorney General's office, and the victim should never get a bill, and their insurer should never get a bill for that. And those include the exam, the collection of the kit, any administration of antibiotics or anything like that that's done as a part of that exam. And if there's an indication for it, the full 28-day cycle of HIV post-exposure prophylaxis, which is also called PEP. So all of those things are covered directly by the Attorney General's office. The victim should not be getting a bill for that. However, we know that when a victim goes in for treatment for sexual assault, there could be other injuries that are treated as well. If the victim has emergency room fees, if they have other injuries that are not a direct result of the sexual assault, if they need drug testing, emergency contraception, the victim could be getting a bill for all of those things. So that's something to consider too. Toxicology and drug testing can be quite expensive, especially because it has to be sent out to specialty labs. And so I always like to make victims aware of these potential out-of-pocket costs. We're going to talk later on about victims' compensation, which is a program run through the Attorney General's office here in Ohio, where victims can recoup these out-of-pocket costs that they've paid for emergency room fees and treatments of injuries and things like that. But it is a reimbursement program, and you do have to apply and go through a process. So this is something that victims just need to be aware of. I always think it's important to let victims know that to get treatment at a hospital, you don't have to report the crime to law enforcement. If you're a child, hospitals are going to be mandated reporters. They are going to share with Child Protective Services and law enforcement if there is known or suspected child abuse. So that's something to bear in mind that our clients need to be aware of. When you talk about law enforcement at the hospital, the law, the Ohio Revised Code, says that these officers should be crisis intervention trained. Within the past several months, it was before, I don't know how much time has gone by that we've been in this pandemic. I mean, I know academically it's been almost five months now, but it feels like it's been 5.5 years. But before this pandemic, I traveled around the state a lot. I did a lot of training. And one of the places that I would train was Ohio Peace Officer Training Academy. I was doing a training there probably a year ago, maybe more now. And I had a lot of sergeants, a lot of lieutenants, kind of the leadership of different police departments from around the state. And I asked them by a show of hands as I was talking with them about victims' rights, how many of them had crisis intervention training in Ohio. And most all of them raised their hands. And then I asked them, of those of you who have had the training, how many of you felt like it was a game changer in the way that you do police work, and specifically the way that you work with victims? And every single person who had had the training said that it was a game changer for them. So I think that that speaks to the importance for law enforcement to get this specialized training and to utilize that when they're working with victims. If the hospital isn't the first person that a victim interacts with, law enforcement will be. And that often sets the tone for the rest of the criminal justice process. All right, now we're going to talk about one of our favorite soapbox issues, which is polygraph. And we're going to ask you a poll question of when do you think legally a victim can be polygraphed?
And just so everyone knows, we will take a break at 10:15, which is in about 5 or 6 minutes, and that'll be 15 minutes long. So hang in there.
I just want to take a second too to thank everyone for your participation in the polls. It's great. I can see how many people we have in attendance versus how many people are participating. And it's awesome to me that everyone is taking the time to participate and be thoughtful about engaging, and I really appreciate that. As I said, we're sitting here in our home offices, which all have gray walls somehow, and staring at a screen for 4 hours. So the participation is really amazing and helpful to us. All right. It looks like 79% of you said that a victim could neither be polygraphed at any time for any reason or for the purposes of beginning or continuing an investigation. What do you think, Morgan? Who has it?
I think I like that answer.
Right. Yeah. 79%. I think the 79% takes it. So we have a law in Ohio. This is the Ohio Revised Code. Basically, that states that law enforcement and prosecutors cannot request or require a victim of a sex crime to undergo a polygraph examination as a condition of beginning or continuing an investigation. So that also eliminates any time, any reason, right? My personal take on polygraphs, and I could spend much more than 5 minutes on this, so I'm kind of glad we're limited by the break, is also in line with the science that we know about the effectiveness of polygraphs. So both the National Organization of Polygraph Examiners and Ohio's statewide organization of polygraph examiners agree that there's really no reason you should ever be polygraphing a victim of a sex crime. The science does not support it. Basically, the same science that supports the notion that polygraphs can be effective for criminal defendants or job applicants is not there when it comes to victims of crime. Victims are going to be experiencing the trauma. Obviously, that's going to throw off a lot of the readings. But on top of that, you're basically asking them to talk about what someone else did. And the thing that makes polygraphs work is that you're asking the person who did something to answer a question of whether they did it from their personal knowledge. So when we get kind of, I call it 6 degrees of Kevin Bacon out from that question of that personal experience, we get less accurate. So that's why the national and the statewide organizations do not endorse and in fact prohibit and discourage the use of polygraphs on sex crimes victims. We have had cases where children have been polygraphed, adults have been polygraphed who are victims of sex crimes. And above and beyond the lack of science, when we ask a victim to take a polygraph, basically what we're telling that victim is, I don't believe you. You haven't done enough to convince me. I'm going to need to hook you up to this little machine and read some of your heart rate and blood pressure. And then, and only then, will I believe you or think that you're telling me the truth. So we're basically telegraphing to them, I don't believe you. Your story isn't credible. And, as we've been discussing, those initial interactions really set the tone for the rest of the criminal justice process and how a victim is going to feel about it. So we have 2 minutes. I'm just going to really quickly touch on domestic violence at the hospital. Just like the Department of Health has protocols for sexual assault victims, they also have protocols for domestic violence victims. And what those protocols center around is really making sure that when a domestic violence victim or a suspected domestic violence victim appears at the hospital, we get them into a safe place, away from any potential offender or a defendant who may have brought them in. We make sure that we're providing them with resources. We're checking their social history and their medical history for red flags. And if we believe that domestic violence may be the cause of a victim's injuries, we're noting that in the victim's medical records. So I'm probably about 30 seconds early, but we can go ahead and take our break at this point. So we'll be back here at 10:30 to talk about investigation. And we hope to see you all back. Please take this time to get some caffeine, get some sugar. Think about how you're going to challenge your friends and neighbors in our upcoming polls. All of that healthy competition stuff. We'll see you guys back here in 15 minutes. Hey everybody, it's 10:30. We're back. Hopefully you were able to caffeinate, and I don't know how to make sugar into a verb in that same way, but whatever that would be, you did that. And I think at this point, we're going to have another checkpoint for our attorneys. So if you wouldn't mind sending a chat to all panelists with your name and your registration number, that would be great. And I am going to turn it over at this point to Morgan to take the lead. And she will absolutely loop me in, and we'll try to keep the fun going.
Okay. And just to clarify, nothing should pop up when we're asking you to type in your license number. You need to click on the chat, and then you can chat that in to all panelists. So there shouldn't be any poll type thing that pops up. And this is the second time that we're asking right now. Okay. We're going to talk about the investigation stage. So the crime has occurred, and now we're going to look at law enforcement and the victim's rights during the investigation stage. So Marsy's law does provide victims the right to reasonable protection from the accused. So again, we've already touched a lot on safety, but at the investigation stage, law enforcement should be handing victims there's an AG, Attorney General's blue book that has things listed in it that are going to explain to victims what rights they have and kind of what the process will look like. There's a little tear out sheet that can go in there that lists all their constitutional rights. And that law enforcement should be giving that to them. This is in conjunction with the right to be informed, but also in order for the victim to protect themselves, they need to know how they can do that. So their initial contact is usually with law enforcement. So it's very important that law enforcement is kind of, going through this. A lot of times what we ask victims in our request for assistance form, were you informed of your rights? A lot of times they say no. And then if we go back and say, were you given this little blue booklet or something, their chances are that they were actually provided that, but they had no clue what it was. They were just handed a lot of paperwork and information and sent on their way. So it's really important that whoever that initial contact is for the victim, it usually is law enforcement, that they are kind of sitting down and explaining, hey, as a victim, you do have these rights. Here are some services that are available. And here's information on how you can get a protection order if that's something that you feel is necessary for you to pursue at this time. And here's my contact information as well, so that you can keep in contact with me throughout the investigation process.
I just wanted to throw in there, as to the constitutional right to safety and protection. Those are some of the more, I think, nebulous concepts that we have in the new constitutional amendment. They're not as specific as some of the rights that say you have a right to be notified of these proceedings, to be present at these particular proceedings. And so I think I like to say that those are opportunities for us as victim attorneys and victim advocates to be creative in terms of what we're arguing that right to protection means. And I did just want to share a recent case of ours. Within the last couple of months, we got this decision from the 12th District where we invoked the victim's right to protection under Marsy's law in a case where an offender convicted of domestic violence was looking to obtain the ability to purchase and use firearms, even though that is prohibited by federal law. And we got a favorable decision from the Court of Appeals that essentially said the victim has this right to safety and protection, and for an Ohio trial court to attempt to allow an offender to disregard federal law and to obtain firearms would be a violation of the victim's right to safety and protection. So again, for me, when you have these kind of ill-defined concepts, that's actually an invitation for you to think outside the box on how that right could apply to get your victim's needs met in the particular circumstance that the victim is in.
So victims are entitled to written notice of all rights provided by Marsy's Law. Again, an easy way to make sure that they're getting this written notice is that blue book. Somebody did ask how officers can obtain those. You can request them from the Attorney General's office. They are free. They will mail you a box of them. Sometimes it takes a few times. You might have to follow up with them. So still continuing on with the right to be informed, after an arrest has been made of an offender, the victim should be given notice that the arrest was made, the name of the defendant or the offender, because sometimes crimes are committed against strangers and they may not know who that offender is, whether the offender is going to be eligible for pretrial release, and the right to call the agency to determine if release is pending. So this is, again, law enforcement is usually the first contact for victims with the system. So we do, ask and expect that law enforcement is going to give them this notice because, again, if they are eligible for pretrial release and that's something that a victim does not know, that could be kind of a Marsy Nicholas type situation where they're bumping into their offender at the grocery store or something like that. And that is obviously going to put the victim at risk and harm. So the legislation, we have some pending legislation that's working its way through the General Assembly. It would provide victims the right to be notified of, present for, and heard at arraignment. Obviously, arraignment is very, very important for a victim's safety. They need to know when arraignment is being held, and they need to know that they have a right to be there and to be heard. If they have safety concerns, that is where they first should and need to be addressed. That's where they can go in and say, please don't release this offender. He is going to kill me. He has threatened to kill me. At that point, all the judge knows is the very basic facts, and they're just setting a bond for the most part. So if a victim can go and, say on their own behalf that, my safety is at risk, I'm fearful for my life, I need protection, it's really important that they be able to participate in the arraignment. The pending legislation, like I said, would mandate that police inform victims of arraignment information. Now, this may sound like an overwhelming task for law enforcement at first glance, but it's not. Essentially, what law enforcement would need to inform the victim of is, hey, sometimes arraignment literally happens within, 12 to 24 hours. It could be coming up at 8 a.m. the next morning, depending on when they've had contact with the victim and when the arrest happens. So kind of making sure that they know arraignment happens quickly, and then also how to obtain information on where that offender is going to be for arraignment. Are they going to be downtown Cincinnati at the Justice Center and Courtroom A, or are they going to be at a more rural area? Depending on where the crime happens, things happen differently in every jurisdiction. So just making sure that they are aware that they can access this information and how to access that information is really important. And moving on to prosecution, which is where the majority of our war stories come in and hopefully the majority of our questions. So keep them coming. An anonymous attendee said, is Vine still in play? So yes, Vine, we do occasionally help victims sign up for Vine, or prosecutors do post-conviction. As far as signing them up right at the beginning, that's obviously an option. I don't know that they would be in the system that quickly. If we're just talking about arraignment, as far as Vine, if you just mean Vine in general, yes, we do encourage victims to sign up for Vine. We're not affiliated with them in any way, and sometimes we do see some issues, specifically if an offender is in a community-based program, like we have the River City program here in Cincinnati. That is not a state institution. That is not a jail or a prison that Vine covers, so they're not going to be in the system in that situation. So Vine does have its pros and cons, but we absolutely do encourage victims to sign up for As far as the right to participate, victims cannot be fired or punished at work for participating in the preparation of a case or attending a hearing. Elizabeth mentioned this earlier, that is one of the biggest concerns for victims is, depending on the severity of the case and whether it's municipal or felony, they're looking at quite a few court appearances if they do want to participate fully in the process and be present for all of those hearings. Sometimes I will tell a victim we're probably looking at 10 to 12 court appearances before this case is resolved. So that's a lot of time off work. Obviously, court hours are the same as most work hours. And as Elizabeth also mentioned, a lot of our clients are low income, living paycheck to paycheck. So that is scary for them. They don't have paid time off. They need that money, and they want to make sure that they're not going to lose their job, or their job isn't going to be in jeopardy based on their participation in the case. And these protections come from the revised code section. So employers who violate this provision can be held in contempt. I have never personally experienced that. And victims, it is kind of a mix of whether or not they do want to be present for everything, such as, a pretrial, if that's something where we're representing them. I will say you have a right to be there, but I can go and represent your interests on your behalf if you don't want to be there. So just making sure that you inform them and let them know that they do have options and they do have rights, and how they decide to participate in the system. There are some protections so that they have options to choose from. Hi, Leah.
Hi, Morgan. We have a question. Someone was wondering if a victim is not able to be at arraignment, is the prosecutor able to convey the victim's concerns to the judge, even though they're not able to be there?
Absolutely. And again, that's kind of an important point, that law enforcement needs to make sure that the victim knows how to get into contact with that prosecutor also. I would say that the ideal option would be for the victim to be present, just because, if arraignment is the next morning, the prosecutor may not even be going to the office before going straight to arraignment court. So there's a chance that they're not checking their voicemails or their emails or something like that before they go straight into arraignment. So that, that absolutely is a good point, that a prosecutor can advocate on behalf of the victim's concerns at arraignment, and oftentimes will, but it's just a matter of making sure that law enforcement is also informing victims of how to get a hold of that contact as well. Elizabeth, do you have anything to add? No? Okay. So our implementing legislation is also going to provide victims employment protection when they attend court to enforce their rights, even if they're not subpoenaed to attend. This is an important point to make also, because I have seen a trend from some prosecutors' offices where they will subpoena victims to every single court hearing, whether it be a pretrial, oral argument, whatever the case may be, because they think that is proof for the victim's work, and also notice to the victim that they are required to give. That's not ideal notice, because it's a court order. So then, if a victim says, hey, I was subpoenaed to this pretrial, do I really need to go? My response is going to be, I'm not going to encourage you to violate a court order. So at that point, you're putting them in a position where is it likely that a judge is going to hold them in contempt for not coming for a subpoena or something? Probably not. But is it a possibility? Yes. And is that a risk that a victim really wants to take? Probably not. So the pending legislation will give them those protections to participate however they see fit or necessary without being subpoenaed. And we have a poll question. Who can act as a victim's representative? I touched on this at the very beginning, introduction type stuff. So again, this is one where you can pick more than one option. All that apply. Okay, and we have some answers. Who of the following can act as a victim's representative? It looks like 99% of you said a professional advocate. 76% said a victim's family member, 64% said a victim's friend, and 67% said a victim's significant other. Actually, any of these people could be a representative on behalf of the victim. Obviously, a professional advocate makes the most sense if that's the role that you're in, or if you work at a prosecutor's office where you do have advocates that attend court with you. We obviously have advocates with our office that are professional advocates and attend court with us as well. But if a victim feels more comfortable with a family member, a friend, or a significant other acting on their behalf as their representative, that is also a possibility. And this is not by any means an exhaustive list of who could be a victim's representative. Leah?
Morgan, we have a question. The question is, does a minor victim have the right to have a parent represent them in court arraignment? This person has had an issue where the parent was not allowed to sit in on the arraignment, and the minor child was too scared to face her attacker during the arraignment.
Yes, a parent can be a minor victim's representative, and I think we even have that exact example in in one of the beginning slides in the introduction. I'm not sure why they were refused access to the arraignment. Obviously, the caveat and the where you have to have some concern is the family member acting on behalf of them, whether it be a parent or someone else. Who is the offender? Do they have any relation to the offender? And are they actually acting on the best behalf of the child? But yes, a minor child can have their parent as a victim representative.
And I would just say that if the person who's asking that question wants us to assist them with ensuring that, going forward, the parent can act as representative, we're more than happy to do that. As Morgan said, we have had, unfortunately, scenarios in the past where family members have attempted to act as a victim representative while advocating for dismissal of the case, or advocating for, the child to be forced to do an interview or something like that. And, the revised code is going to provide the court some leeway to appoint another representative who is acting in the interests of the child victim if the court feels that the parent is not. So without more detail, I think that's great, Morgan, that you brought that up, because that would be a caveat for us.
It looks like we also, go ahead, sorry, Leah.
Sorry, the one point that she wanted to make was that the offender was also a minor. So would that make a difference as to why the parent of the victim would not be allowed?
No, the age should not make a difference in that situation, I don't believe.
We actually have a revised code section that's coming up that makes it clear all of the rights that victims have when their cases include an adult offender also apply to juvenile offenders as well. So Marsy's law and the Ohio Revised Code apply equally to adult and juvenile offenders.
And then we have some questions in the Q&A. Harry says, isn't it true that in some other states a niche industry has sprung up whereby lawyers advertise that they represent victims? I'm not familiar with other states, really. I don't think it's I guess it's a niche industry in that there are not a ton of victims' rights attorneys in general. There are quite a few organizations like ourselves in other states that assist victims with legal representation. As far as the niche industry and advertising that they represent victims, I do see a trend of defense attorneys that represent victims, and my assumption, although I have not ever asked a defense attorney this, is that they are most familiar with the criminal justice process other than prosecutors, obviously, but if the prosecutor can't advocate on behalf of the victim's interest because they have to advocate on behalf of the state's interest and those don't align, I guess victims' thoughts would be that a defense attorney, if a victim's rights attorney does not exist in that area, would be the next best attorney that understands the criminal justice process versus a civil attorney. But I guess I don't know if that answers the question. I'm not sure if it's true or false really in other states, but that seems to be the trend we see in Ohio.
And I would say that there are 11 states at this point that have organizations like ours.
Mhm.
Those organizations would probably, be advertising that we provide services. We certainly have Google ads and things like that. Our services are free. There are, as Morgan said, and through the course of my career here, I have interacted with a lot of defense attorneys who are providing services to victims. Sometimes it's, an attorney who legitimately has concerns with the way a victim's rights have been handled. We've also seen a couple of situations, and I'm hoping these are rare. I've only seen a handful of them personally, where the same defense firm that is representing the criminal defendant is also purporting to represent the victim. In my view, you have to be really careful with things like that. That can easily be a conflict of interest. But we have seen in this state and other states a rise of criminal defense attorneys providing these types of services. In fact, personally, I've had defense attorneys who have been on opposite sides of cases from me reach out and ask me for assistance as they kind of begin to provide representation to victims as well. And we're happy to do that. I think the more folks who are providing services to victims, the better. These defense attorneys obviously didn't believe that they were going to get rich from these cases, and we're really trying to do a public service, and I applaud that. I, again, just, do see a handful of scenarios where there do seem to be some ethical concerns with a defense attorney advocating on behalf of a victim that a case be dismissed while also representing the criminal defendant who incidentally would like the exact same outcome. And, you have a potential appearance of impropriety there.
And then one more live question. If a victim receives a subpoena but is out of county, can she request payment of 1-day appearance fee and mileage allowance before honoring the subpoena as provided in the statute and criminal rules of procedure? I think that would be a fair request. I don't know if it would be honored. But they could certainly ask whether or not they will be reimbursed for their mileage and appearance. I think the subpoena appearance payment in Hamilton County, and don't quote me on this, but I think it's like $7. So I don't know. I mean, that's a discussion that you could certainly have. With COVID happening currently, you may also request that maybe some video teleconferencing type scenario happen instead. I do think that with the coronavirus outbreak, all of these courts are becoming more equipped with technology, and I do think that could potentially allow for some opportunities for victims to participate remotely in stuff like this. Again, you would have to talk to the specific facility that is subpoenaing them and ask what their process is, because I think it would be dependent upon what they can afford or are allowed to charge. These are some facts about advocacy. We obviously see great results from having our advocates fully involved. We really work as a team with our advocates in our regions here at OCVJC. They almost always serve as the point of contact for our victims from the very beginning. They're great at, kind of building that rapport and trust with the victims. Victims feel comfortable communicating with them. And it usually it usually results in, great satisfaction, even if we don't get the result that they were originally hoping for in a case. The fact that they had an advocate there to listen to them and to encourage them and to provide resources to them really does make a huge difference. And I don't know if Leah or Sierra wants to add anything now about their advocacy roles. No? Okay. Well, Leah and Sierra are great advocates, and we love working with them. So, okay, privilege concerns. So, to date in Ohio, stuff that victims share with advocates is not privileged. This is really important to remember. I have not personally had any issues with this, but I go to several outreach meetings, and another organization that assists victims was at a deposition with a victim, and they did have an advocate with them. They took a break from the deposition and went out in the hallway, and the attorney was talking to the victim, and the advocate was there for moral support and emotional support. And luckily, they didn't really talk about anything of substance. She was just kind of calming the victim down and telling her, take your time and don't cuss out the defense attorney. He's just doing his job, kind of thing. And so they went back in, and the victim, started to testify again. And the defense attorney said, so what'd you guys just talk about? And the attorney obviously objected to that and said, that's privileged information. And he said, but it's not, because you had an advocate there. Obviously, she shut that down pretty quickly, but and then she did go ahead and say, you can answer that because we didn't talk about anything. But that is kind of a scary situation to think about if you have an advocate and an attorney talking to a client, and you really just have to make that argument that the advocate is necessary to the conversation, obviously, but it's definitely something that you need to have in the back of your mind, because advocates do not have privilege in their conversations with victims. And another big pointer is that system-based advocates, so prosecutors, offices that provide advocates, if exculpatory evidence were to be shared with that advocate, they do have a duty to tell that prosecutor, and obviously that prosecutor is going to have to hand over that information. So that's something to think about as well.
I just wanted to throw it in here really quick. A lot of the rights that are provided by Marsy's Law that we're getting ready to discuss at the prosecution phase are also provided in the Ohio Revised Code. So what you'll see is what looks like duplicative information of, here's how Marsy's Law frames it, here's how the Revised Code frames it. But really what we want to communicate is simply that most of the rights in Marsy's Law, in fact, the vast majority of them, were pre-existing in the Ohio Revised Code. But as Morgan kind of alluded to in the beginning of the training, for whatever reason, though these rights existed in law, they were not given a tremendous amount of weight in our court system. And we talked about me literally being locked out of a court, even when I first started practicing, which seems like a very long time ago now, all of these rights were on the books at that point, and most of them in the mid 90s existed. And so I just wanted to kind of preface this conversation so that you don't think we're just showing you the same thing over and over again, but instead just trying to let you know that many of these rights were pre-existing, and many of the Marsy's Law rights have support in other areas of the law as well.
So hi, Leah.
Hi, just a quick question going back to attorney-client privilege. We had an attendee ask, does having an advocate present during a discussion between a victim and their attorney affect attorney-client privilege? Just wanted to make sure you guys touched on that fully.
So again, I kind of touched on it, but just briefly, you just have to make sure that that advocate is necessary to the conversation. If the participant in the conversation is a victim, an advocate, and an attorney. You just have to make sure that they are all necessary for the conversation, which I don't think is a hard argument to make when you have a very traumatized victim involved in the conversation. Okay, just how law enforcement has things that they are required to inform the victim of, the prosecutor also has things that they need to be informing the victim of once we get to the prosecution stage. These are listed on this slide. The name of the defendant, again, a lot of crimes happen against strangers, so they may have no idea who the defendant is, especially if they weren't involved in the arraignment process. The case number, procedural steps in the case. This is a big one. You know, as attorneys, I for sure am very guilty of just throwing words out there and moving on and not really explaining what those words mean. Victims are likely not at all privy to the criminal justice system. They have no idea what a pretrial means. They have no idea what a motion to modify bond means. So these are things that you kind of have to explain to them. You know, we're going to have so many pretrials, and that means this. You know, that's really just to make sure that we have discovery in place. Well, what's discovery? Discovery is this, blah, blah, blah. You know, just taking the time to kind of explain to them what's actually going to happen and what they can expect to see can help with, you know, not being so overwhelming of a process for them, and also help with their participation in general, which is usually very helpful to the prosecution in their case. They also need to be informed of what to do if they are threatened. This could be by the offender or someone acting on behalf of the offender. What are their options in that situation? Who should they be informing? Things like that. Contact information of the prosecutor. A lot of times we have victims that ask for our assistance and they have no idea who the prosecutor is on their case. They've never spoken to them. They've never heard from them. And, you know, it's kind of hard for them to get information if they don't know who to contact for that information. So even if it's, you know, just the general prosecutor's office's number that they need to call and, you know, explain, this is what I'm trying to figure out. You know, they just need to have some information on how to get into contact with people to even get the information they need. And then a summary of the victim's rights, and in all caps, the fact that some of these rights have to be requested in order to be exercised. So that is, you know, the right to notification. And so if a victim wants to be notified of court dates and stuff like that, they need to be requesting that in writing to the prosecutor. We have a form that we use that we will put the victim's name on, have them sign, and send in on their behalf. You know, a lot of victims do come to us frustrated that they had no idea that a pretrial already happened, or, you know, they're not being notified of court dates and stuff like that. And we say, well, did you request notice of that? And they're like, no, I had no idea I needed to. So again, it's important that they know their rights from the beginning and how to exercise those rights in order for them to be able to exercise them meaningfully. So if they're not receiving notifications, you know, a victim's rights attorney or the victim on their own can send a letter to the prosecutor that formally requests this notice. Like I said, we have a form that we will fill out the information for the victim, have them sign it and fax it or email it, mail it, however we need to get it to the prosecutor for the victim. Victims also have the right to confer. So this means that if they request to confer with the prosecutor should be conferring with them. This can be as simple as they just want to know what's going to happen at the next court date. It is especially important that a prosecutor confer with them if they've requested that to confer with the prosecutor before the prosecutor dismisses or amends an indictment. You know, I understand that there are circumstances where that comes up and that's the necessary step, but that seems very detrimental to a victim always. So if you can take the time to explain to them, hey, we have to dismiss this because we didn't set forth jurisdiction correctly, and we have to go back and do this again, or I need to amend the indictment because this happened. Whatever the case may be, kind of explaining that to them and answering their questions is very helpful in helping the victims to understand the process and why things are happening the way they are. A big one is before agreeing to a plea. So the way the revised code section writes this out, it's before the plea is accepted in court. So a lot of times victims will come to us and say, they already offered this plea deal and then they came and told me about it and now it's a set thing and I didn't get a voice in this. They didn't even ask me, how I felt about this plea deal, stuff like that. It's a super frustrating and confusing process for victims, always. So taking the time to communicate with them and let them know, hey, we're going to offer this plea deal, and here's why. This is the evidence that we have. This is where our case is not so strong. If I don't believe that I, can convince a jury that he did this, then he may walk away free, or we can offer this plea deal and kind of explaining the situation that way and breaking it down for them is really helpful. Elizabeth, if you can spotlight, thank you. So, that's one of the biggest ones that we see is victims coming to us before a plea deal is taken in court and being really upset that the prosecutor didn't take the time to explain to them why that was happening. I did in one of my counties have a case where we requested to have a meeting with the prosecutor and the investigator, the victim, myself, and an advocate. And we all sat down and the prosecutor did say, here's what we have, here's what we don't have. The investigator explained everything that he did in his investigation and where the evidence was coming up short and why the initial charge was probably not going to be proven beyond a reasonable doubt. And even just explaining how high of a burden beyond a reasonable doubt is and where the downfalls are in the case really helped the victim to understand. And she walked out of that conversation feeling like she was heard. She understood what was happening. Although it wasn't the ideal outcome that she wanted, she was at peace with it. She knew that she was going to get to address the court and tell them how this crime had impacted her. And she was ultimately satisfied with the way the case came out. So a conversation from the beginning of saying this is what we're going to offer and we expect that they are going to take this offer is really helpful. Before trial or an adjudicatory hearing and before pretrial diversion is granted. Hi, Leah.
Hi, it's me again. Just a quick question about conferring that we had from an attendee. It says, is it okay for the prosecutor to have his or her paralegal or victim's advocate talk with the victim? Is that acceptable for the confer requirement?
Yes, that would be acceptable. Obviously, a victim's advocate is not a lawyer, so if they're talking to the prosecutor and getting, the explanation from the prosecutor and then the victim's advocate is explaining that to the victim, that is acceptable. It may be somewhat offensive to the victim or make them feel like the prosecutor doesn't have time for them and doesn't really care about them. But as far as conferring, that would suffice. It would not be my number one suggestion. I understand that prosecutors have lots and lots and lots of cases, and that it's a very overburdened system, but sometimes taking that extra step can really, give the victims that support and trust that they need in the system to be at peace with how things come out. And
if the victim specifically asks for a little bit more information, like directly from the prosecutor, can they ask for that?
Yes, they can ask to speak to the prosecutor.
Yeah, I think that's a great point, Morgan. I think sometimes, obviously it goes without saying that victim advocates, we showed this slide with some, and that's just a few of the amazing stats that we have from actual empirical studies on victim advocate impact in the criminal justice system. But I think sometimes we put advocates in an unfair position where we're asking them to, explain legal concepts and, ultimately become possibly the target of a victim, being upset and frustrated because the advocate may not be able to answer all of the questions, may not have all of the information, and may have to go back to the prosecutor, and the victim may feel like, well, why couldn't I have just spoken with the person that has all of the answers? So I think for the vast majority of things, victim advocates are far superior in terms of, providing information and support and guidance to lawyers. Honestly, everyone who knows me knows that I feel like that. But I think when it comes to legal questions, you're putting an advocate in a tough position where they may be looking at something like unauthorized practice of law by having to give legal advice when really the attorney, the prosecutor, what have you, just needs to jump on that phone call or meeting and explain that to the victim to not compromise an advocate's position.
We have an anonymous victim advocate that posted a question. This person said sometimes in their county, victims rarely speak with the prosecutor, and at times they are left to, quote, clean up the mess that comes with the victim not having a say in the plea deal or amended charge. Any advice for that victim advocate?
I would say that, as I've said multiple times, if you feel like there are issues in your jurisdiction or your county with victims' rights being violated, please reach out to us. We can certainly keep your name out of it. A lot of victims do come to us organically. They find us through Google searches or Google ads and things like that. So it's not as if we have to call the prosecutor and say, let me tell you what Susan told me yesterday about how bad of a job you're doing. And we have had a lot of success with being able to address those types of issues. Just like Morgan said, that's our exact concern, is that the advocates get put in a compromised position where, they're having to answer questions that they don't really have the answers to because these are decisions that they didn't get to make, and they're being told to just, sweep this under the rug, deal with it. And that really is problematic. I think that the reason, especially with crimes like domestic violence and sex crimes, why we have such low reporting, and even on violent crimes, we have pretty low reporting. If only 2/3 of people are reporting crimes, that's still not something that, we should be looking for a trophy on. And I think a part of it is just the reverberations that happen when someone has a bad experience in the system. So I think that we always have to be mindful of the chilling effect that if we give bad advice, if we violate rights, and then folks put that out there on Facebook or Twitter or Snapchat or other app that I'm not cool enough to have heard of, you can really see some huge detriments to the criminal justice process. So we're happy to try to mediate that where we can. We are a statewide organization. Most of our attorneys focus on a region, but it's a pretty large region. And we often have to be the quote unquote bad guy who, rides into town and says, hey, you can do better. Here's how. Please make sure the following rights are protected. So that's our role, and we're more than happy to do that to help out.
Elizabeth, one more question about just clarifying the word confer. If a prosecutor states in a pretrial involving the victim's attorney that he will dismiss the case upon certain conditions and the victim's attorney raises no objections, can the victim then later complain if the complaint is dismissed?
Yeah, ultimately, I think what that question is about is maybe creating an appellate record. If you ultimately want to appeal, I think the issue with that question in terms of the underlying premise is, like we said, victims' rights are designed to give victims a voice, not a veto. So the victim appealing the dismissal of a case is probably going to be a pretty problematic thing. They could say, my voice wasn't heard. And I think the fact that the attorney, did not object at that point could be perceived as problematic by an appeals court. But I think you could also object at the actual time of the dismissal and, say, look, that was clearly a conditional statement, that we had no idea if that was going to actually happen in terms of a dismissal. Now the case has been dismissed and we were not conferred with at that juncture. So we do believe that this is problematic under 2930-06 and Marsy's law. I don't think that an appellate court is going to hold any attorney, whether it's a defense attorney or a victim's rights attorney, to a standard where every time a discussion comes up and something you don't like is said, you have to put an objection on the record. I think you've got to get the objection on the record when the court is making the decision, or when, the prosecutor, if they are the decision maker, is making that decision. That's the time that you need to get that objection on the record. So I think, as a victim's attorney, you would have to probably explain that in the appeals court. I don't think it would be a difficult thing to explain.
So jumping back into our PowerPoint, the pending legislation would mandate that courts inquire whether prosecutors have informed victims about the proceedings and conferred with them appropriately. As far as defining confer, I think basically a conversation suffices for confer. Like the definition of confer, I guess, but the pending legislation would just kind of require the court to ask a question, have you informed the victim of this proceeding today? Have you talked to the victim about your decision? Again, that's not, as Elizabeth has said, that's not going to give the victim a right to veto the prosecutor's decision ultimately, but it just kind of puts another checkpoint in place in the criminal justice system where we are ensuring that victims are being informed if they requested to be notified of that information, and are also making sure that their voices are heard, just making sure that those constitutional rights are being upheld the same as a defendant's would be. The right to be present, so they can be present at any public proceeding, a victim can be. And so, that can be a pretrial, that can be arraignment, that can be a bond modification hearing, the entire process. They have a right to be present. When we get involved in cases, we usually will go ahead and file with our notice of appearance a motion exercising the victim's rights to be present and heard. We will go ahead and address this from the very beginning. Sometimes judges like to address it the minute that it is filed. Other times they kind of wait until there's an objection or an issue that is raised in regards to a victim being present or heard. There are certain ways that, or certain exclusions that make exceptions for victims to even be present during the entirety of the trial, and that is laid out in Evidence Rule 615, which we note in our general motion that we file, saying that even if there is a separation of witnesses, there is a specific exception for a victim that allows the victim to continue to be present throughout the entire trial and throughout other witnesses' testimony. Sometimes defense attorneys will object to that. If they do, it is their burden to prove that their client's rights are going to be affected detrimentally by the victim being present throughout that entire trial. They can't just make some general assertion that the victim is probably going to change their testimony based on other witnesses' testimony, which has no scientific value whatsoever anyway. There is a lot of case law in Ohio specifically about a victim's right to be present. We typically will cite all of these in our motions and then highlight whatever district we're in. Hey, your district has also made this decision that victims can be present throughout the entire trial, and here's what happened in that case, and give a summary that way.
I just wanted to throw in here at this point, because Morgan, you kind of touched on this. a lot of times the arguments for why a victim should not be allowed to be present fall into two camps. One is an argument from defense counsel that it will violate, the defendant's right to a fair trial, defendant's right to due process, things like that. I think those objections have been pretty handily dealt with for about 30 years or over 30 years now by the Ohio courts, and you have some of the cites there. You also have more generalized objections, like Morgan referenced, that a victim may change their testimony. And when defense attorneys raise that with me, or in a case that I'm litigating this right to be present, I always tell them, don't sell yourself short. You've got cross-examination. And I think that that's something that we forget about, right? Cross-examination is pretty much for a trial attorney the most powerful tool in your tool chest. If the victim changes their story from their initial statement, of course you're going to be able to bring that up and impeach their credibility based on that. But more to the point, what we know from years of studies across not just the state but the entire country is that these fears that victims are going to change their story, or that victim's mere presence is going to have some type of untoward effect on a jury, really have not proven to be valid. And as far as I know, there has not been a case where a victim's mere presence has interfered with the defendant's constitutional rights from the federal constitution or state constitution. And I know we have just about an hour because we want to give you plenty of time to take the post-test and the evaluation at the end. But since we've been at this for a couple of hours, I'd like to share a humorous story now about the right to be present. And this is true. I promise you this is true, and it's really funny, and I wish that I could see you laughing because I know at least some of you would. So I was doing a training several years ago, a live training, back before we had a global pandemic, and I was talking about this right to be present. And oftentimes when I'm doing live trainings, people will kind of shoot their hands up and they'll give us a really specific fact pattern of something that's going on in their jurisdiction, and they'll kind of ask how we think victims' rights come into play. So in this particular jurisdiction, there was a concern about how the right to be present was exercised. So essentially, I was told that there was a motorcycle gang, and this motorcycle gang's particular issue of interest was animal abuse. So anytime there was a trial regarding abuse of an animal, the motorcycle gang would attend the trial, and they would make t-shirts, and they would also make t-shirts for the victim. And the t-shirts would have the defendant's face in the center of the shirt, and then below it, it would say, "Serial Dog Murderer." And what this motorcycle gang would do, and what they would try to get the victim to do with them, would be at a dramatic moment of the trial, they would all stand up in unison. I have no idea how they choreographed this. And they would unzip their jackets, and they would show the jury and the judge and everyone in the courtroom this t-shirt with the defendant's face, calling him a serial dog murderer. And this particular court employee that was asking me about this scenario was like, what do we do? I mean, the victims have the right to be present. How do we stop this from happening? And I think that it brings up a very good point, which is that this right is the right to merely be present. This is not the right to make a t-shirt. This is not the right to parade in with picket signs. This is not the right to start a chant in the middle of trial calling someone a serial dog murderer. This is simply the right for the victim to be there throughout the entire trial or other proceeding, to know what's going on. We typically will have talks with our clients before trial when the client is planning on exercising the right to be present, and we'll let them know and try to help them to understand. And I was trying to get at this earlier with the question about defendants' constitutional rights. I get so frustrated when I feel like other attorneys are trying to get people to picture the Constitution like it's a pie. And if I get a bigger piece of the pie, you get a smaller piece of the pie, and everyone wants pie, and I want all the pie, and I don't want you to have any of it. So therefore, if you have rights, I have less rights. That's just not true. I mean, that's not the way our Constitution works. And all of the rights in the criminal justice process, whether it's the rights of the victims, the rights of the defendant, the rights of the press, all of those are important and necessary to the functioning of our criminal justice system, that all of those rights are protected and enforced. And victims have to understand too that if their exercise of rights interferes with a defendant's rights and they wear a t-shirt that says serial dog murderer, the chances that they create a mistrial where we have to try to come back and do this all over again in a couple of months or a year is substantial. And victims don't want that. They don't want delay. They don't want 3 trials. They want finality as much as anyone else in the criminal justice system. And so I think really to help them understand that if everyone's rights aren't protected, we're going to have a problem. Maybe not right now, but at the appellate stage, we will. So we should just be making sure that in the responsible exercise of victims' rights, we're not doing anything that's going to interfere with defendants' rights. And that's something that everyone at my office believes in. The way that we litigate cases is based on that understanding of the Constitution and that position. So although I think the story is really funny, my answer to that individual was, there has to be a conversation with the victims. Don't engage in this. Don't encourage this. This could be problematic for a later appeal for the defendant's rights. So I think that it is important to understand that this right is limited in that regard, and responsible exercise of all of these rights it's crucial to ensure that the criminal justice process functions the way that it should.
Hi, another question from an anonymous attendee. As we're talking about these Marsy's Law rights, can you share examples of what types of remedies that have been provided when that particular right has been violated?
Yeah, absolutely. So with the right to be present, specifically, we have not had to take this issue up to the appellate courts. There is a lot of case law, a lot of pre-existing law in Ohio that makes it pretty clear that the victim should have the right to be present. So essentially, we file a motion asserting that right. And as an office, we have never had a court deny that motion and not allow a victim to exercise that right. So we've been very lucky in that regard. In regards to the right to confer, again, we haven't had this come up in Ohio. We've been lucky in that regard. But in other jurisdictions that have substantially similar rights to Marsy's Law rights, when the right to confer or the right to notice is not protected and enforced by the court, we have had some limited circumstances where victims have moved successfully to reopen that hearing to ensure that their voice is a part of judicial decision making. So as I said, when it comes to reopening a plea, we have not had that particular experience. We've been lucky in Ohio that we haven't had to take that type of a step or try to take that type of a step, because it is an incredibly complicated thing that does involve defendants' rights and does require a balancing of all of these constitutional rights when you're considering taking that step. But as we continue to go through, we can absolutely talk about remedies, and thank you for that question. So Morgan, I'll take it off of you for a minute, and then you can jump in if you want to add anything, and then I'll throw it back to you when I get tired of talking.
Okay, sounds good. Can you spotlight Stephanie, please?
Absolutely, and thank you for the reminder. So as Morgan said, and I don't want to belabor this point, but as a practice pointer, if you're representing victims, we assert the right to be present and the right to be heard very early on. We want to make sure that we aren't interfering with speedy trial and that we are resolving any issues or disputes that we may have with the prosecutor or the defense counsel or even the judge at an early date. So if we have a client who at that point tells us, yeah, I think I do want to go to the trial, or I do want to be present for these evidentiary hearings, we'll go ahead and assert that right very early on. And I think that that's a large part of the success that we've had. So before we talk about the right to be heard, we have a poll on, and again, not giving away the answer first, so I feel good about that, but when do you think a victim has the right to be heard? And this is also multiple choice. You can choose as many of them as you think are applicable. And we still have a great poll response rate, so thank you for the participation. It almost seems like it's a little bit easier than if I had you raise your hand, if we were live, because that would require actual physical exertion. So. All right, so 83% said before sentencing, 80% before the court accepts a plea bargain, 76 before release of an offender, 78 before disposition of the case, and 90% anytime a victim's right is implicated. So actually all of these are correct. Let's go to our next slide here. So essentially, when you look at the text of the constitutional amendment, and this, by the way, I'm going to flag for you because this right to be heard is new to Marsy's law. There's an expansion that occurs in the right to be heard that is new to Marsy's law. And basically, Marsy's law guarantees that anytime a court is making a decision regarding release, plea, sentencing, disposition, which would include the dismissal of a case, or if you're talking about post-conviction when parole is being considered, or any time a victim's right is implicated, the victim has the right to be heard directly by the court. I know when Marsy's law first passed and I was talking to a lot of judges, they said, oh my goodness, the courtrooms are gonna be crazy, victims are gonna be standing up and asserting their rights. And I told them, I said, you all may forget, but you all are scary. I'm scared of you. All the lawyers I know are kind of scared of you. Victims are definitely going to be nervous when they're in a courtroom setting. And so I think over the past couple of years, what has proven to be true is that we don't have a lot of victims standing up, having these cinematic courtroom moments where they're asserting their rights. And instead, we're seeing victims' rights being asserted in much the same way that they were asserted before Marsy's law, which is with the help of victim advocates or other victim representatives, with the help of attorneys like Morgan and I who do this work, and primarily with the help of prosecutors who have been and I think will always remain on the front lines of ensuring that victims' rights are protected. So it's pretty much been business as usual for our courts, despite fears that this particular right would be exercised in a way that was problematic.
Elizabeth, we have a question. I think this is in regards to our practice pointer that you can file a motion. It says, so the courts treat victims' rights as ones that need to be asserted or otherwise are considered waived. So do courts only address victims' rights if they're asserted or otherwise assume they're waived?
Yeah, so that's a great question. The right to be present specifically in the Constitution is automatic. I don't think a court could treat that as waived if not asserted. There are other rights that constitutionally and statutorily require a victim to take affirmative action to assert, like the right to notification of proceedings, the right to confer in the constitutional amendment. Those things require an affirmative action by the victim, but the vast majority of the rights guaranteed by Marsy's law are basically supposed to work automatically. Now, with that being said, our practice, especially around rights that are traditionally controversial, would be to assert that right anyway, just so there's no question about it. The last thing that we want is to delay a trial because we assumed that the court was going to be on board with the victim's right to be present because it's existed for 30 years. And we learn, during jury selection that the court is not comfortable with it. And so we need to brief the court and make an argument and things like that. So I think in terms of best practices, way to do this type of representation, you want to assert everything in advance just so you can't later be accused of causing a delay or, not being aware of, different defendants' rights that may be implicated by asserting rights later on. So I guess, long story short, while the rights are automatic, we still assert them because we think that that's just the best practice. So just like the right to be present, we also assert the right to be heard pre-trial, meaning we don't wait until the day before the trial. In fact, we often assert the right to be present and the right to be heard in the exact same motion at the exact same time, because frankly, these rights often come up together. If a victim is attending a hearing, chances are one of their rights are probably implicated in that hearing or could possibly be implicated. And we just want to make the court aware we're going to be there. First off, prosecutor, we want notice. Part two, we're going to be there. And if a right is implicated, we want to be heard on that. So again, this has worked really well for us in creating predictability. When you talk about the right to safety, and this is not from Marsy's law, Morgan touched on this, I think, quite a bit when she was talking about arraignment, but don't forget about criminal protection orders. We'll talk very briefly at the end of the presentation about civil protection orders, but suffice it to say, our preference is always to get that TPO or criminal protection order if it's available, so that our client doesn't have to go through the civil protection order process while they're also going through the criminal process. So it's very important to be aware of how your jurisdiction deals with criminal protection orders. There are truly 88 kingdoms when it comes to this, maybe closer to 150 kingdoms. And so knowing how your jurisdiction works is very important, and making victims aware of the opportunity, usually at arraignment, to seek a criminal protection order is one of the key things that we do. So victims also have pretty similar to a speedy trial right that's provided by Marsy's law and also the revised code. So it's proceedings free from unreasonable delay and a prompt conclusion. Unreasonable, prompt, these are definitely words that may not have the same meaning to people who don't practice law or who don't work in the criminal justice system. The reality is the vast majority of criminal cases, felony cases especially, you're looking at probably approximately a year from start to finish, from indictment to the end of the process, whether it ends with a plea or it ends with a trial. More high-level felonies, your sex crimes, your homicide crimes, now you're stretching that out closer to 2 years. And for homicide crimes, especially murder, sometimes 3 years can actually be reasonable in terms of the time it takes to bring that case to trial. So helping victims to understand that is really key. As I mentioned in the beginning of the presentation, we often work with victims before they've even reported. We had one case where we were working with a family well in advance of the time that the case was indicted. And the second we learned that there was an indictment, the mother of the child victims came to me and said, "Oh, good. So we have a trial date set now for 2 months from now. I'm so glad this is almost over." And I said, this is not almost over. We're probably not going to trial in 2 months. We're probably going to trial in a year. And so if you set the expectations, that's really key. I know Morgan touched on this when she talked about those early conversations with the prosecutor, but really just taking the time early on to make sure that the victim understands the process will save criminal justice system officials a lot of headache in the back end. And we also, as I said, have this statutory right to object to unreasonable delays as well. Works substantially similar. The legislation does have a provision that basically says victims are allowed to weigh in when it comes to continuances, which we really didn't need. This isn't necessary because the Constitution already says victims have a right to be heard anytime their rights are implicated. So that's not really that big of a change there. So in terms of a practice pointer for this, again, you really have to work with someone who's familiar with the criminal justice system and have a good sense of whether the delay really is unreasonable. But an example of a case where we had an absolutely unreasonable delay was a rape case, and there were also some kidnapping charges as well. But by the time the victim contacted us, it had been almost 4 years from the date of the indictment. I think we can all agree, unless something really bizarre is happening in that case, that is an unreasonable delay. Ultimately, we got to the bottom of what was happening, and I had kind of a humorous but also a very disheartening conversation with the defense attorney, where he basically told me that because he felt the evidence was so strong against his client, his only card to play was to try to delay the case until someone dies or retires or the victim gets sick of this crap. And he was very forthcoming that that was his strategy and what he felt he ethically had to do. That, unfortunately, is not a reasonable cause for delay. And so in that particular case, we did file the complaint for the extraordinary writ, and specifically a mandamus, where we asked the appeals court to instruct the trial court to take the case forward. And that's ultimately what happened, and the offender was convicted in that case. So I guess his attorney was right. The evidence was very strong.
Elizabeth, we have a hypothetical.
Okay.
Arthur poses this to you. The trial has already happened. The judgment has not yet been rendered. The court is holding an SAR. I don't know the abbreviation, SAR. Circumstances have changed now, and there's new information that's going to be presented outside of the trial. Is this allowed when it may affect what's in the best interest of the victim?
I'm not, so when you say circumstances have changed and there's new information being presented outside of what was adduced at trial, I'm not 100% sure on the specifics of that, because obviously mitigation evidence for sentencing is going to, if you're, I mean, you're saying that the verdict hasn't come back, so I don't know if you're saying that we don't have a conviction or we just haven't wrapped up sentencing. I guess if you have a conviction but you're waiting on sentencing, there's going to be new information that comes in because the defendant has the right to not take the stand. And so they're going to present mitigation evidence, and that's just something that's going to happen. In terms of if the court is looking at accepting new evidence after the trial has concluded, I'm not sure I don't know how to put this except to say I don't think that's a thing. And I would certainly be willing to talk with you more about that, but I've never heard of a scenario where something like that has happened. I don't actually think that's permissible. It could be a weird scenario that I'm just not familiar with, but generally speaking, mitigation evidence that comes in as to sentencing isn't favorable to the victim, but nevertheless, there's statutory authorization for that type of stuff to come in. The victim also has the ability to present information as to sentencing as well. But I don't, in terms of new evidence being considered before reaching the decision of whether to find a defendant guilty or not guilty, once both parties have rested, I guess just procedurally, I don't know how that would work. Do we have any clarification on that?
SAR is semi-annual review, he says, and then he gave us his contact information, so maybe we can follow up.
Okay, that sounds great. Yeah, we can absolutely follow up, but it sounds not right.
Yeah, okay, and then an anonymous attendee said that the county that he or she works in usually does provide a TPO during arraignment, but the bigger issue she sees is that a civil order won't be issued if someone waits. I'm assuming for the criminal case to be concluded. Does Marsy's law apply to civil courts?
So that's actually a really interesting question that has a very long answer, but well, I can make it short by saying it depends, because that's the traditional lawyer answer. In terms of application of Marsy's law, specifically to civil protection order matters, that is something we do very little in CPOs. Most of the stuff that we do is criminal court stuff. But I have heard around the state that some lawyers have been successful in applying Marsy's law to CPOs in some jurisdictions, and other lawyers have been unsuccessful in other jurisdictions. So I think it's going to be largely dependent on your jurisdiction. There's one case in the entire United States on point, and it's out of Arizona. And it basically says if there is a pending criminal case, Marsy's law protections or victim constitutional protections can be applied to that civil case to prevent a criminal defendant from using a civil matter to circumvent the protections that would otherwise exist.
I did have a case in one region where we were going to attempt to do something. And so she was, the victim they were waiting for the criminal case. It was an ongoing investigation, so there weren't charges yet. She went ahead and filed for the civil protection order, and the defense attorney requested a deposition of her, and we did file something, a motion arguing that she had the right to refuse a discovery request, deposition, or interview on behalf of the defendant or his counsel, but we ended up going ahead and dismissing that. She dismissed her civil protection order in order to pursue the criminal case first instead. So we did not end up getting a decision on that, but we were looking into trying to cross the courts there for a minute.
And I will say this about the question that was framed as, there's a problem with the courts being willing to issue a civil protection order if the victim waits. I think there are more problems, and the court should see this, if the victim doesn't wait. One, you're asking a criminal defendant who has the right against self-incrimination to take the stand in another case to defend themselves, or else you're asking them to just allow the protection order, to be granted, which is, both of those things would be problematic from the criminal defense standpoint. So most of the courts that I know of, if there is a CPO filed at the same time as a criminal case, they'll put the CPO on hold. They may provide the victim with that intermediate protection while the criminal case is pending. But I think that there can be a lot of problems that can be generated by the interplay of a CPO and a criminal case, for both a criminal defendant and for a victim who is going to be subjected to discovery requests and things like that would never fly in the criminal case. So, I think that that's kind of an education piece with the court as to the problems as to both folks' constitutional rights, to forcing victims to do a CPO while a criminal case is pending.
And one last question before we move on. If a victim is not given the opportunity to be heard before a change of plea hearing, what would the remedy for that violation be?
Yeah, so that would be the remedy that, like I was talking about with the right to confer as well, where you would actually be asking the court to reopen that hearing to permit the victim the right to be heard. The issue with reopening a plea hearing is there's a lot of risk for a victim. So let's say that the victim is okay with the plea deal, but they just wish that they had been given an opportunity to be heard. If they ask for a reopening of the plea, the criminal defendant is going to be given an opportunity to reconsider whether they like that plea or not. And they could potentially, that could result in the rescission of that plea, meaning it's as if the plea never happened. If we get so far out that not only do we have a plea, but we've also had a conviction, a sentence, and all of that package, and we're at the end of the case and the victim has just learned about this and would like to look at some type of remedy. When you talk about reopening a conviction, you run into those double jeopardy issues where in attempting to assure that a victim's voice is heard, you could potentially inadvertently lead to a dismissal due to double jeopardy. So I think that is an incredibly complicated situation where a victim really needs to be fully advised of the potential risks and benefits to make an informed decision. If you have a case like that, we're more than happy to talk it through with you and the victim, but just know it is incredibly complicated. There are a lot of defendants' constitutional rights at play, and we, as I said, we have to be cognizant of that.
If you could go ahead and spotlight Ashley before we move on.
Thank you. All right, so we've talked about this provision at length in the beginning, so blissfully we get to skip over this now, which is great. I want to touch on some other smaller things really quickly. This right to privacy that currently exists in 2930.07 can essentially allow so that the victim's contact information is removed from public record we would argue that Marsy's law would allow that as well. But this is a hearing that a prosecutor can ask for, and once they make the request, the hearing has to occur. So a great way to get victim name and contact information, or sorry, victim contact information specifically, out of public record. We also in the past have had some success with bond reconsideration, invoking the right to safety and protection for the victim, especially where you have a defendant who keeps violating the terms of his release. Oftentimes, prosecutors will be the ones to make the request that bond be revoked, but victim attorneys also have the ability to do this, at least as far as we're concerned, to invoke that right to safety and protection that's provided by the Constitution. So this is, again, something creative that we thought we would just try and was actually effective a couple of different times. So something to keep in mind when you're thinking about that more nebulous concept of safety and protection. We also have some special rights that only apply to certain victims. So if you are a victim of a violent crime or a sex crime who is under the age of 13 at the time that the crime is charged, like the indictment or the complaint, or if you're a victim of human trafficking under the age of 16, or if you're a victim who has developmental disabilities, all of those folks are going to be able to seek to do an alternative testimony. So either by closed circuit TV, which is where a victim is maybe in judges' chambers separate from the other folks in the courtroom, including the defendant, and they're being broadcast into the courtroom while they're being questioned. The defense attorney can go back into chambers to do questioning. The prosecutor can do that. It's broadcast into the courtroom by video, but it's not forcing the child victim or the victim with developmental disabilities to be in the same room with the offender. This can be a huge benefit to child victims who are really hesitant to go forward, especially because, as we've talked about throughout, oftentimes child victims are victimized by folks they know. But on the flip side of that coin, as a child, to be victimized by a stranger is an equally terrifying experience. Either way, you don't want to be 6 feet away from that individual. And you also have the opportunity to do a videotape deposition as well. At the videotape deposition, the defendant may still be allowed to be present. So those are details that have to be worked out between defense counsel, prosecutor, and the court. But these are testimonial alternatives that can at least make a smaller group of people present when a child victim or a victim with developmental disabilities is giving testimony. Like the other motions that we file, we will file this one early on. Typically, we'll work with prosecutors and see if we can get them to file the motion because that's what the statute contemplates. But again, we think that this really implicates safety and privacy for victims. And so, and we have in certain circumstances filed these motions on behalf of victims. The right to safety also includes this revised code section that says victims and offenders should be given separate waiting areas. This is a simple thing, but a pretty important thing. There's nothing more unnerving for a victim than to be waiting for the case to be called and the defendant comes and plops down beside them on the only bench outside the courtroom. So really, as an advocate or counsel for a victim, working with that courthouse to get a private space that is safe for the victim when you're waiting is very important. All right, now, as we continue to talk about privacy, let's talk about whether you think some evidence comes in or is excluded. Believe it or not, folks, we have just about 35 minutes left. So it's almost DoorDash time, which is very exciting, I'm sure, for everyone. All right, it looks like the results are in. 45% of people think the defendant's sexual history with the victim comes in. 5% of people think the victim's sexual history with other folks comes in. Only 1% think that the fact that the victim was sexually assaulted as a child comes in, and 49% of you said that none of those would come in. All
Almost
right, Morgan.
even split.
It is a very even split, but Morgan, illuminate.
Oh, unfortunately, although we would prefer that none of these come in, the victim's sexual history with the defendant in some situations is going to come in. That does hold some probative value if there were several instances of consent prior to the crime happening.
Yeah, that is the case. The victim's sexual history with other people is not going to come in based on the assumption that you're making in the parenthetical. And we have some relatively recent case law reaffirming that the fact that the victim was sexually assaulted as a child is also not going to come in. So we're pretty limited there to just the victim's sexual history with the defendant coming in.
I do have a question before we move on. An anonymous attendee has a case where the defendant continues to violate the temporary protection order that's in place. He is usually arrested, but then continues to be released on bond and is not coming back to court for hearings. She's a DV liaison, he or she, can they bring this up to the prosecutor as a violation of safety for the victim?
Absolutely. And I'm sure that the prosecutor is probably pretty frustrated with this turn of events as well. Some of these rights, as we talked about in the beginning, Marsy's Law gives prosecutors the right to assert these rights on behalf of victims if the victim would like the prosecutor to do that. And so I think that this does give prosecutors some unique opportunities to assert a right that has constitutional dimension. Before, the prosecutor was kind of just saying, this isn't right, judge, we shouldn't be allowing this guy keeps violating. But now the prosecutor can say there's actually constitutional rights at stake. So I think it's a great thing to bring to the prosecutor's attention and see if they're willing to bring that to the judge's attention.
I think that would also be a great case to maybe try to reconsider bond in general, file a motion.
Absolutely. Absolutely. So as to rape shield, which is what we were talking about with the previous poll question, hopefully it's pretty clear, but for the most part, a victim's sexual history does not come into a criminal case, the exception being sexual history with the defendant. There was a long tradition prior to some case law that came out in the late 70s and early 80s about kind of putting the victim on trial and looking at the victim and their previous sexual history and basically trying to suggest that if you ever had consensual sex with anyone before, you probably had consensual sex with this person this time. And obviously that's a logical fallacy. You could have consensual sex with the same person and they could still sexually assault you. And so with that being said, the Supreme Court really began to look closely at this in the late 70s and said, no, we don't think this comes in. And that was later codified in the Ohio Revised Code. Just like the other motions, you can absolutely assert rape shield in two different ways. One, you can preempt it. If you think that you have a case where the defense is going to try to bring in this rape shield information, you can file a preemptive motion asking the court to go ahead and put this on the table. Let this be a topic of conversation now so we can get this worked out. Or you can wait until that comes in and then file a memo in opposition to the defendant's motion to introduce this evidence. If you are litigating this, there's going to be a hearing. It's probably going to happen in chambers. It's usually a private hearing. And in that hearing, the defense is going to have to establish that they meet some exception to rape shield. And if they're unable to do that, the evidence is not going to come in. Oh no, we gave away this answer earlier, but let's see if people remembered. What about juvenile courts? Another great turnout, and it's looking pretty good. All right. So
Oh, the nose. Where were you earlier?
yeah. So by and large, victims of juvenile offenders are going to have the same rights as victims of adult offenders. In fact, if I were going to argue that this statement was untrue, I would say that actually victims of juvenile offenders, especially if they're child victims, which is often the case, could have additional rights. So they may actually have more rights, but the reality is juvenile offenders and juvenile courts have to comply with Marsy's law. They have to comply with the Ohio Revised Code, and all of those rights that exist for adult offenders are going to exist equally for juvenile offenders. All right, let's keep it rolling. So we're at the end of the criminal justice process at this point, which is very exciting. But it's important to continue to give victims information, even once the case has concluded, and we've decided, basically a jury or a judge has decided, or there's been a plea finding that the person was either guilty or not guilty. Victims still need to have notification of what happened. Not every victim is going to want to go to trial and sit through that and wait for a jury verdict. Some of them will, some of them will not. If they do not, let them know as a prosecutor that there was an acquittal or a conviction. If there was a conviction and there's going to be a pre-sentence investigation, the victim needs to get the contact info for the probation officer who's conducting that PSI. They need to be told that as a victim, they have the right to be heard in sentencing, both through a victim impact statement, which can be given live or in writing at the sentencing hearing, but also as a part of an impact statement that's presented to the court in the pre-sentence investigation. One important caveat is that the victim impact statement can be disclosed to the defendant. So what the law says is that if a defendant requests to see a copy of it, the court can allow it. The defendant is not allowed to retain a copy of it. They have to give it back. They're not allowed to keep it, but they are allowed to view it. And so for that reason, a lot of our clients will choose to, instead of giving a written impact statement in advance, they'll choose to attend the sentencing and give a victim impact statement live, where they're not passing off a copy of that to the criminal defendant. Again, if it's in writing, the defendant gets to view. If the victim brings up new material information as a part of the impact statement, there may be a continuation of that hearing to give the defendant a chance to respond. Anyone who meets the constitutional definition of victim, that broadened definition, keep that in mind, is going to have the ability to give an impact statement. Other family members, neighbors, friends who don't technically meet the definition can still give an impact statement upon court approval. So we've talked about some significant changes to Marsy's law as we've been that Marsy's law brought to Ohio Victims' Rights Law as we've been going through. The right to appellate review, the explicit standing rights, those are big ones. The right to be heard is also a big change in that expansion. And the last one is the right to restitution. The right to restitution under Marsy's law is mandatory, meaning victims have a constitutional right to full and timely restitution. That is a 180 from our previous statutory law, which basically said a victim can bring all of this evidence to prove that they're entitled to restitution. Restitution, by the way, is just a court order that the defendant pay the victim back for their out-of-pocket losses that resulted from the crime. So the victim could bring in all this evidence, they could present it all to the court, they could testify as to the value of lost property or injuries or medical bills or anything like that. And the court could say, thank you so much for sharing, I'm giving you $0. Now, under Marsy's law, if the victim can prove their losses by what is called competent, credible evidence, the victim is entitled to restitution. And this is one of the areas where we have been very successful in several different courts, appeals courts around the state, to reopen sentencing when a defendant has not been ordered to pay a victim restitution, but the victim has provided that competent, credible evidence. So I'm going to throw it over to you, Morgan, to talk about your latest victory on restitution in Ohio.
So we got involved in a case. It was one of my first cases when I got to OCVJC, and I still have it. So it has been a long time coming, but we had a victim reach out to us. Her car was stolen and wrecked and then abandoned. So by the time the car was recovered, it was totaled. And the offender pled as charged and was sentenced to 18 months in prison. The victim, it was a husband and a wife. The wife was the titled owner of the car. The husband was driving the car, had the car at work, and that's where it was stolen. So both victims, in our opinion, he was the named victim on the report, and she was obviously the titled owner, which makes her a victim. So anyway, they did not make it to sentencing. They were told they didn't need to be there, but that if they wanted to submit a victim impact statement through the pre-sentence investigation, they could. And the advocate with the prosecutor's office sent them the paperwork. They filled it out, and they attached 3 different estimates, repair estimates that they had taken on the car, a receipt for towing and making a new key for the car, which were their out-of-pocket expenses, and then a Kelly Blue Book estimate, and then pictures of the car. They attached all of that to their victim impact statement and asked for restitution and a stay-away order. There is some confusion about what exactly was provided to the judge out of the pre-sentence investigation packet that they sent back, and the advocate has since retired. So we have never gotten full confirmation on that, but that is what they told me they submitted. So when they came to us, obviously the judge didn't award any restitution. He just sentenced the offender to prison and called it a day. So when they reached out to us, it had already been past the 30 days for an appeal of that decision. And so I went to Elizabeth and said, what do I do with this case? And she said, let's try a writ of mandamus. So we filed a writ of mandamus asking the 12th District Appellate Court to order the judge to award restitution, reopen the sentencing and award restitution. We litigated that to the full extent, but before we got a decision from the 12th District, the judge his counsel approached me and said that, they felt that we made some strong arguments and they're not anti-victim, and they couldn't argue against my constitutional points with a straight face, and they would agree to have the restitution hearing. So it was scheduled back in November of 2019. Unfortunately, the offender was released from prison early. He was no longer in prison, and he was not on post-release control. So we had a hard time getting into contact with him. His defense counsel also argued procedurally that the judge and the trial court did not have jurisdiction while the writ of mandamus was still pending, which I argued against. I said there have been several instances where judges have righted their wrongs, and then the writ in the appellate court is just dismissed because it's moot at that point. In the meantime of finally tracking down the offender, the 12th District did come down with an opinion granting the writ of mandamus in part. In the writ of mandamus, we had asked that the court order the judge to reopen sentencing to hold a restitution hearing, but we also put a specific amount of restitution in that writ of $3,021 based on the Kelly Blue Book estimate. And so the 12th district said, yes, you have to open resentencing, you have to hold this restitution hearing, but the trial court judge does have discretion in the amount. You need to prove that by competent, credible evidence. Good luck. So we did finally hold the restitution hearing just recently, and we do not have a restitution decision from the judge yet, but that was one of our good victories for restitution, and since we have gotten several new restitution cases. So.
Hi, ladies. We have a couple questions about restitution. Looks like this is a hot topic.
Hey, Leah, I do want to say, we'll try to address these as briefly as possible. We have like 8 minutes to get through quite a few slides because I want to leave 10 minutes at the end for the post-test and the evaluation. So just to kind of put that out there for further questions.
Sure. One question was, does restitution include time lost for work? What about loss of a job, loss of income, moving expenses, and when it's needed for safety? That's one.
Yes, I think you could make an argument that restitution included all of those things.
Okay. And also, is restitution still mandatory in juvenile court after losses are proven? Doesn't the juvenile magistrate need to consider the defendant's ability to pay?
No, restitution is mandatory in juvenile court. The ability to pay can be factored into the payment schedule, but it cannot be factored into the overall restitution award because there is a constitutional right to full and timely restitution that applies to both juvenile and adult offenders. All right, just kind of wanted to briefly touch on a couple of things here and try to wrap us up on time. So we talked about compensation earlier. Compensation comes into play and requires similar proof to restitution, but compensation can be sought after there's just a police report. You don't have to wait for a criminal conviction. This is applied for in the Attorney General's office. There are some requirements in terms of, the victim, previous criminal history, if any, and things like that. So if you need assistance with restitution, contact an advocate or contact our office. With compensation, contact an advocate or contact our office, and we'll be happy to walk through that and assist in any way that we can. A note about compensation: if you get compensation and you later get restitution for the exact same losses, you'll be required to pay compensation back. So you can't double recover and make a profit. Essentially, you will have to pay compensation back at that point. Victims have the right to get their property back at the end of a case. Oftentimes, police can simply photograph things when evidence could be needed or images of evidence could be needed for appeal. But by and large, at the end of a trial, victims should be getting their property back. We talked about continuing notices, and that includes appeal. It's important that prosecutors let victims know when appeals are filed, but also how appeals work. When victims see appeals, it's a very scary moment for them where they think, oh my gosh, this person was given 50 years and they filed this appeal and now they're getting out of prison. In reality, probably not, but victims don't understand that. So an explanation is really important there. When it comes to post-conviction, we're kind of back to notification, information, and protection. So we talked about the right upon request to release of an offender that would happen pre-trial. That right from the Constitution applies post-conviction as well. Judges are going to have some notification requirements if they do a judicial release. Otherwise, the Department of Rehabilitation and Correction or the Department of Youth Services is going to provide these notifications to victims. Even though Marsy's law says that the notifications are provided upon request, the revised code actually requires the Department of Rehabilitation and Correction or the Department of Youth Services to provide these automatically if you're a victim of a first, second, or third degree violent felony. We talked about VINE, so that's good. Briefly on professional conduct, although I think we covered this pretty well, prosecutors represent the state of Ohio. They're not attorneys for victims. And so it's really important to clarify those roles. We kind of talked about some of this professional conduct and how you have problems with that at times. But essentially, don't forget that lawyers do have professional conduct obligations, both prosecutors and defense attorneys and victims attorneys, that prohibit us from making false statements to third parties or, trying to trick a third party. Talking to represented parties is a big one. So if a victim's attorney is involved in your case as a prosecutor, as a defense attorney, you need to reach out to that victim attorney before communicating directly with their client, or you may be in violation of that professional conduct rule. We talked about not being misleading, also not taking actions that are burdensome, meant to embarrass or harass another person, including a victim. Those things are all prohibited by the rules of professional conduct. I'm going to fly very quickly through federal victims' rights. But suffice it to say, you'll see from this laundry list that they are substantially similar to Marsy's law rights. So the Crime Victims' Rights Act is the federal law that was passed in 2004 that provides federal rights to crime victims, and those are enforced by extraordinary writs, the same as we're currently using for Marsy's law. And I really like that the United States Attorney General's office not only says, of course we have to provide victims with rights, but how else can we help? And if you look at their website, they have a series of things that they will do to facilitate victim involvement in the criminal justice process, which is awesome. The Fourth Amendment, as Morgan kind of alluded to, we use the Fourth Amendment when criminal defense attorneys are asking for the ability to access the homes of our clients without a search warrant. And so far, we've had mixed results on that. One court said, yes, a trial court can't give a defense attorney permission to search a victim's home. Another court said, yeah, we think that they can. And we currently have that case in the Supreme Court of Ohio. I'm going to skip the last poll, unfortunately. We already talked at decent length about protection orders, civil protection orders. Be aware that if you have a criminal protection order and then you go get the ex parte CPO, some jurisdictions are going to say that your criminal protection order is now wiped out. If you don't ultimately get the full CPO, that can be very problematic for a victim. So that's something to bear in mind. We also help with Title IX. Title IX is the Wild West right now. We have new regulations. There are lawsuits that are trying to prevent these regulations from going into effect. Stay tuned. I recommend the Ohio Alliance to End Sexual Violence on very in-depth conversations and trainings on Title IX. Just want to take a quick second to point out that the Americans with Disabilities Act is going to underlie all of the things that we're doing in the criminal justice process. I'll also give a plug here to Disability Rights Ohio, which can help if you feel that your client's ADA rights are being violated by criminal justice system actors. Another thing that we can help with would be immigration needs for crime victims. So T visas for victims of trafficking, U visas for victims of a lot of violent crimes, and the VAWA self-petition for victims of domestic violence are all immigration relief that is available for victims of crime. You have some information here about our services. Hopefully throughout the course of this conversation, it's been pretty clear to you what we provide in terms of services and what our mission is. And then you have a website as well for the Victims' Rights Toolkit, which has all of the laws and the rights that we've talked about today, and about 600 other ones as well. So please visit the Victims' Rights Toolkit. We're very proud of it. It puts all of these rights in chronological order by phase of the process to try to make it easy for victims to understand and access. You have some information about how to refer clients to us and the fact that our referral process is privileged. And now, as promised, I would ask that you please take the post test. We'll take a quick second to go through that. And attorneys, this would be the third time that we're asking you to submit your name and your registration number in the chat to all panelists so that we can verify your continued presence and cooperation. I don't want to put pressure on anyone, but we do expect you to all get 100%. So just want to put that out there. No pressure, but 100%. We'll give just about another minute on the post-test, and then we will go over that and open up the evaluation. While a few of you are finishing up the post-test here, I just wanted to thank you all for joining us today on behalf of myself and Morgan and Leah and Sierra as well. We really appreciate it. You may think that I'm sucking up right now so that you give me a good evaluation, but that could not be further from the truth. And really, truly, we appreciate your questions, your participation, your willingness to push back a little bit and challenge us a little bit, which we actually really enjoy. So thank you all so much. At the end of this, you'll have, I think specifically my contact information. Please feel free to reach out to me anytime. If you have a question, if you need assistance, if you have a client that you think needs help, we're more than happy to step in. We are statewide, our services are free, so we'd be glad to provide any assistance that we could. It looks like we have had the slow trickle maybe stop with the poll, so I'm going to go ahead and end the poll and share the results. All right, Morgan, how does it look to you?
At first glance, it's looking pretty good. There's an even split on a few. So we've still got a toss-up.
Yep, so victims in Ohio have constitutional rights. 96% of you said that that was true, and that is true. They have Ohio constitutional rights. I'm wondering if the 4% of you who said that was false were thinking of United States constitutional rights. So that would be true. They don't have those, so I'll give you an out there. Victims don't have rights until the case reaches the prosecution stage. 97% of you said that that's false, and that is the correct answer. A victim is the party to the criminal case. Interesting split here. This is false. A victim is not a party. They are a third party. So the parties to a criminal case are the state, which is the prosecutor, and the defense, the criminal defendant. The victim is not a party. The press is not a party. There are other folks who may have rights as a part of the criminal justice process, but they're not parties to the case. Victims have the right to be heard by the court anytime their rights are implicated. Yay, 99% of you said that is true, and that is true. So that's great. Question 5, victims can be present for any public hearing unless the defendant objects, and then they're excluded. That is false. The defense has to do more than just object. The defense has to make a showing that one of the defendant's constitutional rights is going to be burdened by the victim's presence. So something to keep in mind, it's more than just a simple objection. All of Ohio courts that have taken up this issue have said there needs to be some type of showing by the defense. Number 6, definition of victim can include parents of child victims and surviving family members of homicide victims. 99% of you said true, and that is correct. All victims get notified automatically if an offender is going to be released from prison. That is false. And I know we covered that very quickly, so I take the blame on this one. But it actually, automatic notices are only to victims whose offender is incarcerated in DRC or DYS for a violent first, second, or third degree felony. Everybody else is going to be required to request notice. If they make that request, they're going to get the notifications. In the Ohio Constitution, the Ohio Revised Code, a victim representative means a professional victim's advocate or a victim's attorney, but not members of the victim's family or friends. That is false. Family members, friends, any one of the victim's choosing except the defendant could be a victim representative. If the defendant asks the victim for an interview before trial, the victim has to say yes. 99% of you said that that was false, and that is correct. Child victims have fewer rights than adult victims. 99% of you said that that is false, and that is also correct. Great job, everyone. This leaves us 2 minutes for the evaluation, which will be plenty of time to tell us how much you love Morgan. So please go ahead and fill that out now. And here is my contact information. And again, we appreciate you joining us today. Want to take a moment too to thank Stephanie and Ashley for their amazing interpretation services. I warned them at the beginning that I am a fast talker. I'm sure I lived up to that, and I apologize, not only for today, but for any other time that they may be forced to interact with me. But thanks to you both, and thank you so much for the OCVJC staff that participated today as well. Just we have a great team, and I'm really thankful for all of you guys.
Also, Leah did provide our Marsy's Law email address in the chat if you guys want to copy that and hold on to that. Any further questions that you have that we didn't have time to address today or about specific cases, you can feel free to send to that email address or Elizabeth.
I just wanted to acknowledge, I know we're a couple minutes over time here, and we're still seeing some responses slowly trickle in. So we will leave the evaluation up for just another couple minutes to give any last minute folks a chance to chime in, and to thank you all again for joining us. But you're free to go if you've completed the evaluation, and we hope that we will see you again. And we'll be able to speak with you too in the future and help any of your clients that may require assistance too. All right, Sierra, I think we're good to wrap up the poll. Um, and we'll be signing off. Again, feel free to contact us if there's ever anything that we can assist you with. And thank you so much for joining us today.